House will come back to order. House will come back to order. Mr. Clerk, you want to ring the bell? Clerk will read the caption to a group of privileged resolutions.
Recognizing, commending Kelly Robinson on his outstanding public service. Recognizing, commending Sonia Compton on her outstanding public service. Recognizing, commending the contributions of Georgia Asian Americans and Pacific Islanders. And recognizing March 13, 2019 is Georgia Asian American Lobby Day at the state capitol. Honoring and commending Larry Blackman. Recognizing and commending Georgia Youth Science and Technology Centers. Commending and congratulating Thomas Sharpless. Commending and congratulating Harrison Stadler. Commending Chief Billy Grogan. Honoring the life memory of Barbara Jean Justice. Commending the State of Israel and condemning anti-Semitism in all its forms. Recognizing the week of September 8th through September 14th as Pulmonary Fibrosis Research and Awareness Week. Commending and congratulating Mary Dorothy Gary. Recognizing, commending Coach Jeff Collins upon his selection as head coach of the Georgia Tech football team. Recognizing and commending Dr. G.P. Bud Peterson upon his retirement as president of Georgia Tech. Honoring Dr. Curtis Jones upon being named the 2019 National Superintendent of the Year. And recognizing April 7, 2019 is Dr. Curtis Jones Day at the state capitol. Commending Reverend Dr. Jamal Harrison Bryant in his appointment as senior pastor of New Birth Missionary Baptist Church. Recognizing Mr. Leroy Childs for exemplary service to public libraries in the state of Georgia. Recognizing and commending Terrence and Cecilia Lester, founders of Love Beyond Walls. Recognizing and commending the National Association for the Education of Homeless Children and Youth. Honoring the life and memory of Maura Binkley and commending the formation of Maura's Voice. Recognizing March 7th, 2019 as Electric Vehicle Day at the state capitol. Commending the University System of Georgia Outstanding Scholars on Academic Recognition Day for 2019. Recognizing and commending the United Hemophilia Foundation and its founders. Commending and congratulating Homer Hunter Sr. And for other purposes, that completes the reading of the privileged resolutions.
Is there any objection to the adoption of the privileged resolutions? The chair hears none, and the resolutions are adopted. We are going back to the rules calendar. Clerk will read the caption to House Bill 168.
House Bill 168 by Taylor, the 173rd, to be entitled an act to amend Code Section 48.8.3, the official code of Georgia annotated relating the exemptions from sales and use tax, so as to extend an exemption from sales and use tax for 5 additional years. This bill having referred to the Committee on Ways and Means, that committee recommends that this bill do pass.
Chair recognizes Chairman Taylor to present the bill.
Thank you, Mr. Speaker. Members of the House, today I bring you House Bill 168. This is an extension of a tax exemption for our federally qualified health centers. These are the community centers that are offering help to those that are medically underserved. I would appreciate your consideration.
You have no questions.
Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 168 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 168. The ayes are 164, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 332.
House Bill 332 by Representative Meeks, the 178th, to be entitled an act to amend Article 2 of Chapter 8 of Title 2 of the Official Code of Georgia annotated relating to agricultural commodity commissions generally, so as to revise provisions relating to service of the Commissioner of Agriculture. This bill having referred to the Committee on Agriculture and Consumer Affairs. That committee recommends that this bill do pass by committee substitute.
Have we met?
I think so, yes, sir.
Good to see you, Representative Nimmer. I'm sorry. Chair recognizes Representative Meeks to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, I bring before you today for consideration House Bill 332. It amends the Commodity Promotion Act, which gives the Agriculture Commissioner the ability to designate an appointee to attend the meetings, the commission meetings on their behalf, and have a vote at those meetings. I'll be happy to entertain any questions. Mr. Speaker.
Well, you have them intimidated. You have no questions.
Well, with that, Mr. Speaker, I'll yield the well.
Better hurry. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 332 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. A man of principle. On the passage of House Bill 332, the ayes are 172. The nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 118.
House Bill 118 by Representative Morris, the 26th, and others, to be entitled an act to amend Article 2 of Chapter 10 of Title 16 of the Official Code of Georgia annotated relating to obstruction of public administration and related offenses so as to revise the offense of transmitting a false alarm. This bill having been referred to the Committee on Public Safety and Homeland Security. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Morris to present the bill.
Thank you, Mr. Speaker, members of the House. I rise today to ask your support on House Bill 118. And what 118 does, it is an unlawful request for emergency services. Some of you have heard this term that it might be referred to as swatting. So let me explain to you the scenario really quickly. I want you to imagine that you've stepped off an airplane at Hartsfield Airport. You look at a monitor. You see emergency vehicles that are in front of a house, SWAT teams, ambulances, fire department, police, and you go, wow, that neighborhood looks familiar. And then you notice, not only is that neighborhood familiar, that's your house. And under there it says that the adult in the home has killed the children and that they're holding the police at bay. You hop in your car, you run to the North Metro Atlanta to find out, thankfully, that those children are sitting in the back of an emergency vehicle. They're protected, they're safe, and the whole thing was a false alarm that someone put in an unlawful request for emergency services. That scenario happened in our city last year. January 2018, situation arose where a ex-mother-in-law puts in a similar sort of false claim for emergency services on her daughter-in-law, saying that she had hurt the children, that she was armed, that she was going to hurt others. The police showed up, and by the time that it was over, this young woman who was not guilty, and the person that put in the call had no basis for putting in this call. By the time it was over, shots had been exchanged, and an innocent civilian had been killed. So what these people that put in these false claims do is they put our civilians at danger, they put our law enforcement at danger, and it's a very hyped up situation that we just really do not want to have in this state. So what this bill does is that it raises the penalties from a misdemeanor to a felony if you knowingly put in a call that you know not to be true. Now, this protects the good Samaritans, and so if someone's putting in a call and they just think something is wrong, these people are protected there, okay, because they assume that something had happened in there and there was a basis for making the call. We've met with the sheriffs, we've met with police chiefs, we've met with the prosecuting attorneys, counsel. They're all on board with this. They've had a chance to review the law, and we believe that this is a good bill for Georgia and for our citizens. And with that, Mr. Speaker, I yield the well.
You have no questions.
Thank you, Mr. Speaker.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 118 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 118. The ayes are 151, the nays are 20. This bill, having received the requisite constitutional majority, is therefore passed. The clerk will read the caption to House Bill 311.
House Bill 311 by Representative Welch in the 110th be titled an act to amend Chapter 21 of Title 50, Title 36, Part 1 of Article 3 of Chapter 3 of Title 23, and Code Section 5, 6, 34, the official code of Georgia annotated relating to waiver of sovereign immunity. This bill having referred to the Committee on Judiciary. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Welch to present the bill.
Thank you, Mr. Speaker. Good afternoon, members of the Georgia House. I present to you House Bill 311. This is a waiver of sovereign immunity bill. You have seen a version of this bill over the last 2 sessions, and you have voted 177 to 0, I believe, last year in support of this measure. If you'll recall, let me just simply put what we're doing here is this. We are opening up the courthouse doors for our citizens to come back in and sue if they need to for when they believe a statute or an official action by an individual of government at the state or local level is in contravention to our state or federal constitutions or state law or rule or regulation if it's a local government. The Supreme Court ruled in Lathrop versus Deal, and I'll read from Justice Blackwell's statement. Simply put, the constitutional doctrine of sovereign immunity forbids our courts to entertain a lawsuit against the state without its consent. We are the consenting body. As the General Assembly, we will determine what suits come forward to the courts. In other words, you, each one of us, hold the keys to the courthouse when it comes to challenging government action. And you all represent who? You represent the citizens of this state. Remember, our democracy is based upon the governed giving authority to us to represent them here. It doesn't work the other way around. The governed needs an ability to sue when they think that government has gone astray from the constitutional mandates and that social contract that we have. And in fact, if you look back at the Declaration of Independence, that's exactly what Thomas Jefferson put forth in the Declaration, a list of grievances that the king would not hear. And so I ask you today to support House Bill 311 so that we can open up Georgia's courthouses to our citizens to allow them to sue and bring their grievances for constitutional and statutory violations. And with that, Mr. Speaker, I'll take any questions.
Do you yield for questions?
I do.
Chair recognizes Representative Dreyer to your left for a question.
Does the chairman yield?
I do.
Isn't it true, Chairman Welch, that you worked very hard to include as much waiver of sovereign immunity so that citizens could have recourse against their government as possible in this bill?
I would say that the entire Judiciary Committee worked diligently and very hard on ensuring that there was a substantial waiver of sovereign immunity for its citizens of the state.
Does the gentleman further yield?
I do.
And do you believe this bill is the most waiver of sovereign immunity for our citizens that we can get at this time?
At this time, I think this is as much as we can advance. At this time, I think this is the appropriate measure for the moment. And I hope that we will revisit it over the course of the next coming years should those courthouse doors not be fully ajar.
Thank you, Representative.
Do you further yield?
I do.
Chair recognizes Representative Holcomb to your left for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
I do.
Isn't it true that if we don't pass this measure, then our courthouse doors will remain closed to citizens on numerous issues that are constitutional, and citizens don't have the right to address their government on those issues?
Not inside the courthouse, not within the judiciary. You would not be able to seek declaratory judgment or injunctive relief, and that is set forth plainly by the Georgia Supreme Court in Lathrop versus Deal, Sustainable Coast, and the Oliveira case.
Thank you for your work on this measure, Chairman Welch.
Thank you, Representative.
Do you further yield?
One more, Mr. Speaker.
Chair recognizes Representative Hutchinson to your right for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, I do.
Is it not true that with this law, or with this bill passed, any parent with a child in foster care can sue DFACS?
No, under this particular measure, if the person claimed a constitutional violation or a statutory violation, then yes, there would be redress for that only in the terms of a declaratory relief or injunctive relief.
Do you yield for another question?
Sure.
Follow-up? Just with many years of experience with parents and children defects, just about everybody feels that way. So is there a fiscal note just in case all of the parents who feel they've been unjustly removed of their parental rights decides to invoke this rule?
There is no cost to the state in this legislation. It actually bars monetary relief.
But somebody's budget would have to be increased to handle all of these complaints.
And over the last several decades, this state has been subject, and prior to these decisions of Sustainable Coast in 2012, I believe it was, or 13, Oliver and Lathrop, the courthouse doors were open. So in terms of being able to sue for redress, we've been able to do that under our laws of the state up until that time. So in terms of changing this, we're actually just going back to the way the law was understood to be beforehand, and now we're doing our job as a General Assembly. If you vote for the bill and it passes, then I think we'll have done our job to the General Assembly to allow for citizens to seek that redress, which has now been closed to us since these recent decisions.
Thank you.
Thank you. With that, Mr. Speaker, I would ask for your favorable consideration of House Bill 311.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 311 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 311. The ayes are 168, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 91.
House Bill 91 by Representative Welch of the 110th and others to be entitled an act to amend Chapter 7 and Title 31 of the Official Code of Georgia annotated relating to regulation and construction of hospitals and other healthcare facilities. This bill having referred to the Committee on Judiciary, that committee recommends that this bill do pass.
Chair recognizes Chairman Welch to present the bill.
Thank you, Mr. Speaker. I present to you House Bill 91. This is a bill that is at the request of the Department of Public Health. And in this bill we have, Community Health. And in this bill you'll see that what we're doing is we're authorizing the use of the wrap-back procedures that we had voted on and approved last year to better safeguard our elderly from abuse and financial exploitation. The Department of Community Health has requested this legislation. And this would allow the GBI to use the wrap-back fingerprint system to ensure that owners and applicants and employees of specific long-term care facilities and on the caregivers registry, the Georgia Caregivers Registry, were not convicted of a crime that would otherwise lead to physical, mental, or financial abuse. You'll recall in 2018 we had adopted this legislation in Senate Bill 336, and that was the wrap-back procedures. But where we see this arising is that our elderly folks that are in assisted living care facilities have licensed employees that we should know whether or not the individuals have engaged in abuse somewhere else in the United States or somewhere else in the state. And also we should be advised as to whether or not they've been convicted of any crimes relative to fraud. This legislation would allow that to be monitored on an ongoing basis. Current law merely allows for a one-time check of their federal background check and the Georgia background check, a one-time check. And then for the period of 24 months or up to 3 years, there may not be another check. So in the interim, if someone is convicted, it may not be known to that license holder as their employees or to the individuals that are part of the department. And so we ask for your favorable consideration of this measure, as we think it will be a great benefit to the department and also to the protection of elderly citizens of Georgia. And with that, Mr. Speaker, I'll take any questions.
You have a question if you care to yield.
I do.
Chair recognizes the minority leader of the House, Leader Trammell, to your left for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
I do.
Isn't it a fair way to sum up that it's a real-time look, live time versus a snapshot?
It is a real-time look at one's criminal background, yes.
Will the gentleman further yield?
I do.
And you would agree that the purpose and intent behind and when this is implemented, it will better protect our seniors in long-term care facilities as a result of having this long-term or the real-time access to the fingerprint database?
I would agree, yes.
You have no further questions.
Thank you, Mr. Speaker. I yield the well.
Gentleman has yielded the well. Is there any objection? Oh, got a speaker. I'm sorry, Mr. Leader. Hope you will forgive me. Chair recognizes the minority leader to speak to the bill.
Thank you, Mr. Speaker and members of this House. This is going to be an extended day, so I'm going to be succinct. But just like this bill best protects our seniors who are in long-term care facilities with having a real-time ability to check the fingerprint database, we should do the same thing with the weapons carry license permit fingerprints. Because when we take a snapshot, when we're giving someone the ability to carry a concealed weapon, we don't know what happens after that snapshot. And this very same policy that this General Assembly has decided to implement and make available to every department and agency is literally available to any agency except for the weapons carry permit license. And we just need to make that available because it makes sense. It's common sense. Mr. Speaker, I support this measure, urge favorable passage of it, and I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 91 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 91. The ayes are 168, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 353.
House Bill 353 by Representative Carpenter IV and others to be entitled an act to amend Chapter 1 of Title 33, the official code of Georgia annotated relating the general provisions regarding insurance so as to create the crime of staging a motor vehicle collision. This bill having referred to the Committee on Insurance, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Carpenter to present the bill.
Good afternoon, friends. House, I come before you for House Bill 353. The purpose of this bill is to codify staying a motor vehicle collision as insurance fraud. It is currently being prosecuted under the insurance fraud in Title 33 of Georgia Code, but that section is very vague in regards to car insurance fraud. The punishments in this bill are less than current insurance fraud. I say again, the punishments in this bill are less than current insurance fraud. This bill will deter staging these accidents that are currently costing consumers and businesses billions of dollars each year. I ask for your favorable consideration. He's going to cut into his. I yield the well, I guess. Thank you. I appreciate it.
You have questions.
Oh, so close. So close. I yield.
Either that or they want to place an order off your menu. I'm not sure which.
We'll be accepting those soon.
Chair recognizes Chairman F. Stration to your left for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
I yield.
Is it not true that in the Insurance Committee you were subjected to the lawyer's treatment, the lawyer's questioning on your bill here?
It was devastating.
And isn't it true that you've worked with the prosecutors to ensure that the elements of the criminal offenses here are consistent with the criminal conduct we're trying to capture, and that it won't in any way sideline other appropriate prosecutions under Georgia law? Is that fair?
That is correct. I was also found it funny there wasn't a lot of 133s on 2 bills ago on Andy Welch's bill, but thank you.
And isn't it true that the sponsor's been willing to work through all those issues and we have a good bill now?
Absolutely. Thank you.
Thank you.
Chair recognizes the Minority Caucus Whip, Representative Bodie, to your left for a question.
Does gentleman yield?
I definitely yield for you, sir.
Now, isn't it true that in current code we have a misdemeanor offense of filing false police report as a crime? Is that?
That's correct. Yeah.
And also in code we also have filing false statements in writing and concealing facts as a crime, which is a felony. Is that not true?
That's correct.
And is it not true that these particular crimes are also used in prosecuting the type of crime that you are bringing to the floor today?
I would assume they are, but F.S. Stration might know a little bit better on that than me.
But it is a possibility.
That's absolutely a possibility.
Yes, thank you.
Thank you.
Do you further yield?
This is it. This is the final one, sir.
Chair recognizes Representative Holly to your right for a question.
Thank you, Chairman. Thank you, Speaker. Mr. Chairman, do you yield?
Yes, sir.
Is it true that in the staging of an accident that you have various members who have been able to stage that, some to a lesser degree, some to a higher degree?
I would say maybe that's the case. Yes, sir.
And so, Mr. Gentleman, yield?
Absolutely.
In order for this to be, for each of the members in that staged accident, because there is a varying degree of intent with an intent for this bill to actually violate it, how are you able to establish that each member in that scheme should be charged of a felony if there's varying degrees of intent to which to actually to violate this?
Sure, I would actually leave that up to the prosecutors. So, thank you for your time. Appreciate your favorable consideration.
Is there any objection to the previous question being ordered? I'm sorry. Got one speaker. Chair recognizes Representative McLaurin to speak to the bill.
Thank you, Mr. Speaker. Colleagues, I rise before you today because of the principle that criminal justice is about balance. This is sort of an odd bill for me to make my first appearance, but it's because it's a larger principle that matters to me. Having interned a little bit on both the prosecution and defense side, I can say one of the things I've really enjoyed about being on Chairman F. Stration's Judiciary and Non-Civil Committee is there's a lot of attention paid to proportionality and balance in sentencing. And I think that if there's a need to create a new crime, which in this case there may be, we've always got to be sensitive, I believe, to the penalties that we're imposing and make sure that they truly do fit the circumstances. And I want to cue in on something that the sponsor mentioned. It's not that we're really leaving it to prosecutors here if you look at the specific offenses. In fact, we are taking discretion away from prosecutors when it comes to one of the sentencing provisions here. If you look at lines 17 through 21, we create a new crime called aggravated staging of a collision. And this could be actually causing a collision, but it could also be faking one, which means no actual motor vehicle activity. And if we're faking one, I just want to set up a hypothetical for you. This is stuff we do in the non-civil committee all the time. If I took a baseball bat to a bumper to try to create some quick damage to make a fraudulent insurance claim, and on the backswing I hit my friend in the knee, that's an injury. And the statute just says any violation of A which results in personal injury. It doesn't say serious, it doesn't say serious bodily harm, it's any injury. So if that baseball bat causes a bruise, that's a minimum of 5 years. Just to be clear, that's a minimum 5-year sentence. And I want to put that in context. Sexual battery against somebody less than 16 years old is a minimum of 1 year. Child molestation on the first offense is a minimum of 5 years. That's the level of seriousness we're talking about when we start with a minimum sentence of 5 years. So I understand a lot of people might vote for this bill because of the need to close a gap in the insurance fraud statute, which again is already a felony with a minimum of 1. But I just want to be clear, I think we do have a responsibility, especially when we're taking away freedom, and we disagree on a lot of substantive things in this House, but there's a universal concept of freedom I think we can all aspire to that compels me to vote against a sentence that is too harsh and is not proportional to circumstances. Thank you. I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 353 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Representative Carpenter rise?
Parliamentary, sir.
State your inquiry.
Is it not true that here in a little bit we'll be voting on 426 that will allow for enhancement to current penalties in court? Charges, sorry.
Oh, I'm not sure what we're going to be voting on. I'm just along for the ride. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 353. The ayes are 93, the nays are 76. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 444.
House Bill 444 by Representative Reeves of the 34th to be entitled an act to amend Title 20 of the Official Code of Georgia Annotated relating to education so as to revise the Move On When Ready Act and dual credit course. This bill having referred to the Committee on Education. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Reeves to present the bill.
Thank you, Mr. Speaker. Members of the House, I bring you House Bill 444. This is a bill to help clarify and reform a few aspects of Georgia's very successful dual enrollment program. What is dual enrollment? Dual enrollment is a program that allows high school students in Georgia to take post-secondary courses and receive credit simultaneously for both the post-secondary institution and high school credit. When a student graduates from high school and they enter post-secondary school, they enter ahead by having already earned credits towards a university academic degree, a technical school degree, or an associate's degree or apprenticeship program. In some cases, they can actually earn the technical associate's or apprenticeship degree by the time they graduate high school. This program has been highly successful. Currently, as it appears in law, it has no budget boundaries or limitations. The cost of this program back in 2015 was $23 million, and it's ballooned to fiscal year 2020 to the budget of $126 million, and this is actually the highest growing government program in the state by cost. What this bill does is it seeks to bring sustainability and a defined purpose to the program. And this is important. This effort does not seek to limit the options of our students, but rather to balance it with sustainability for our state budget. From the onset, and this is very important to understand, and I've had conversations with many of you about this bill over the last week or two. It's very important to understand there are two sources of funding from which students can receive funding for post-secondary education while in high school. Number one is money from the state budget, and number two, lottery and HOPE money for secondary and also for dual enrollment. This bill seeks to limit the state budget funded portion to 30 hours of dual enrollment, and in doing so, will allow our state budget, what we do in this room, to have a sustainable line item each year for dual enrollment. But it does not take away from our students' ability to dual enroll, as they will be allowed, once they have used the 30 hours of state funding, to use the other funding source and dip in to their lottery/HOPE funding to cover high school dual enrollment for post-secondary coverage. So what essentially this does is it creates a combined budget effort, 30 hours from the state, and then if the student is still continuing to dual enroll, they can dip in to their HOPE and lottery funds. So per the bill, and this is important, everybody please understand this, a student that's on a University System of Georgia track or a TCSG track will have 157 hours of credit covered by the state via the state budget and the lottery HOPE. Will have 157 credit hours available to dual enroll in high school. Again, the state budget will cover 30, and the lottery/HOPE currently covers 127 hours. That's a total of 157 hours. There's not a bachelor's or a technical degree in Georgia that cannot be obtained with 157 hours of coverage. Again, a different way to say it, every bachelor's degree or technical degree in Georgia can be obtained and paid for by the state to an eligible student with the 157 hours that Georgia generously covers. This bill simply puts a limit on one portion, and that's the state funding portion. This bill makes perfect sense, everyone. High school dual enrollment credit hours are designed to be taken to transfer to their post-secondary degree. Most, if not all, should transfer. And thus the credits that one obtains when they use their 30 hours of state-funded, plus any that they dip into with their 127 lottery/HOPE funds, should transfer to the post-secondary institution that they attend, which means that the degree obtained by them will ultimately they will need far less hours than the 127 HOPE hours that they would otherwise have available to them upon graduation if they qualify for the HOPE scholarship. The same applies to associates and apprenticeship programs. Many of you have had questions concerning this. High school students seeking associates or apprenticeship or technical programs have access to the same 157 hours of state plus lottery funds to use while in high school. Upon graduation, depending on GPA eligibility at high school graduation, they can either continue to access their lottery funds, or if their GPA is between 2.0 and 2.99, they will have access to 63 additional HOPE grant hours for technical programs. These 63 hours of HOPE grant credits are not impacted, and this is important because there's a lot of misunderstanding about this. These 63 hours of HOPE grant credits are not impacted by the use of lottery hours while dual enrolling in high school. If a student dual enrolls in high school and then obtains eligibility for the 63 Hope Grant hours, again, there's not a program in the entire state that they cannot get a certificate or diploma that the state won't be able to fully cover with those hours. Other things that the bill does is counseling. This bill requires that dual enrollment students receive counseling from a college or technical school counselor before they dual enroll at 15 hours and then again at 30 hours. And the purpose of this is very simple. We want to ensure that these students who are dual enrolling are taking courses that put them on the track that they desire to be on by dual enrolling, and make sure that they're not taking courses that are not going to transfer to the programs that they seek to get into. This is great because it helps to ensure that it's being used for the proper purpose. Members, this has been a very fluid bill, and it's changed quite a bit from its introduction, and I want to make clear the process is going to continue to be fluid. I expect the bill to continue to change as it goes through the Senate as we work to find the best balance possible for our students and the state budget with this. Many of you had voiced concerns to me. We have addressed some of those, and we are going to continue to address those. There have been a lot of discussion about whether freshmen or sophomores should be allowed to dual enroll. The bill as it is limits it for University System of Georgia to 11th and 12th grade. We are still in discussions about whether or not that is the best and right policy, and we'll continue to talk about that. In the same light, a lot of you have expressed concerns that ninth graders should be able to dual enroll at technical schools. That is something that we are also still talking about, and we are going to consider those arguments and changing the bill to make sure that we have hit this just right. There have been some issues that have been raised to me as soon as last night and today. Some involving transportation. There's a part of the bill that strikes the transportation requirements for transportation to be provided by the state. That was actually a budget item that was eliminated in 2018. This bill brings our law consistent with how our budget is currently operating, and if that is something that needs consideration again, then the proper way to address it would be through the budgeting process. But currently, that portion of this bill just squares the bill up with how we're budgeting right now. And also, I want to stress again how much concern I've heard concerning this Hope Grant. And I've double, triple, quadruple checked that no matter, you can dual enroll your heart out in high school, but no matter how many hours you use when you graduate, that you are eligible for 63 Hope Grant hours, no matter how much you dual enrolled as a high school student, to preserve that Hope Grant technical pathway for our students. Mr. Speaker, I will yield for questions.
You have several.
I had a feeling.
Do you yield?
Sure.
Chair recognizes the chair of the House Appropriations Committee, Chairman England, to your right for a question.
Does gentleman yield?
I do.
Thank you for, I know you've put a lot of work into this. Chairman Dickey, Chairman Jaspers, Chairman Knight, many others put an awful lot of work into this. Just one real short question. Without the guardrails and the framework that this bill puts in place to ensure access to dual enrollment for students for years going forward, is it not true that due to the rate of growth that at some point we would be forced to come in and put an actual expenditure cap on what we're doing in dual enrollment because of the steep climb, thus possibly at some point limiting the number of children that even have access to the program?
That's absolutely right, and it also brings me back to the point I made a minute ago about why this makes so much sense. There is this funding mechanism that is sitting out there that's offering to pay 127 hours of college course credit or technical or credit for students. And if those students are getting credit in high school, then there's no reason why that money that's provided by the lottery that's sitting there shouldn't be able to be accessed while they're in high school. And in doing so, it doesn't harm the student, but it does save the state budget money. I'll further yield.
Chair recognizes Representative Al Williams to your left for a question.
My friend in Noel, yield.
I will yield. Can we talk about oysters?
You've made a compelling argument, and I've listened closely to you, and a couple of things cry out for an answer.
Okay.
It has been successful.
Mm-hmm.
And I remember when this General Assembly thought this was the best thing since sliced bread. But I also remember that as a little girl, I was told my wife's father brought 2 little beautiful bunnies for Easter, a male and a female. In a short period of time, rabbits were everywhere. And the fault rests with there was not a lot of thought put into it before. It becomes disappointing, is it not true, when you promise something and the rules change from success. I remember a gentleman who wanted to be governor of this great state was championing this, and everybody loved it. I think there should be a lot more thought put into bills before we love them one year, and a few years later, if they're successful, it's one of the few things can happen that success cuts into the benefit. Now, I know there's cost involved, but what about the great success of the program? Is it not so that you bought a couple of rabbits and didn't check out the reproduction rate?
I cannot tell you who bought these rabbits and where they took them and what they did. But what I can tell you, and thank you for your question, and I appreciate it, and I've learned a lot about this issue since this session began. And Representative Williams, from the model that's being proposed here in the legislation, I do not believe that this seeks to limit the success. It puts parameters around it in the sense of what we fund in this room with our state budget, but it covers that with other funds that the lottery, which is in very healthy shape right now, the lottery has provided those funds for those students. And since these students are getting college credit in high school, why not utilize those funds that already exist for them and put them in place here, which helps our state budget? It doesn't limit, and again, we are offering 157 hours of credit coverage to any student in Georgia. 157 hours while dual enrolling, and then based on their GPA eligibility after high school. There is no GPA eligibility while dual enrolling during high school, but after high school, based on their GPA, further coverage. And Representative Williams, that is, I believe, the most generous program in the entire country. And I do not believe that this is going to inhibit its success. I think that this is a necessary adjustment, but I don't think that it's going to stop anyone from dual enrolling. And I do not have a crystal ball, and I don't know what those bunnies are going to do tomorrow or the next year. But I have a feeling that if those bunnies stop producing, then we would come back and look at this again.
With further yield.
Sure.
Thank you, sir. Your benevolence warms my heart.
I just try to be like you. That's all. That's it.
And your love for the future of rabbits is truly moving.
I will further yield, Mr. Speaker.
You want more questions?
I'll yield the well.
I mean, it's up to you. There's 2 or 3 more bills left for us to take up today, but gentlemen can yield. We have others that wish to be heard. On the bill, Chair recognizes the Minority Caucus Whip, Representative Bodie, to speak to the bill. I would remind the speakers now that we are in the 30 minutes per each side time frame.
Thank you, Mr. Speaker. Today I rise in complete opposition to House Bill 44 because it negatively affects one of our most precious natural resources in this state, our talented students and our next generation of leaders. I understand that there may be some funding issues or parameter issues with our current dual enrollment program in Georgia. However, members of this General Assembly, I ask you to take a step back. Let's pause. Let's work on some valuable solutions with this dual enrollment program for our students. Why not address dual enrollment with a working committee? Why not address dual enrollment with a study committee? And let's come up with a reasonable compromise. What's the rush? As my colleague said earlier, this program has been around a long time, actually since 1992. It has been very successful. I have three major concerns with HB 44. The dual enrollment bill, it eliminates ninth graders from taking tech and vocational classes at a technical college while they're in high school. Why does a ninth grade student have to wait a full calendar year to start learning a valuable trade and craft that he or she could use to further their life when they become adult? If the ninth grade student is talented and driven to pursue their dreams, why not allow them to do that the first day of their high school career in the ninth grade? Why should that student have to wait to the 10th grade? I also want to talk about high school students taking uncovered credits. The money would come from the lottery funds, and those uncovered credits be used against the student's whole scholarship limit of 190 quarter hours or 127 semester hours. So now what does that mean? I'm gonna tell you what it means. It means that a high school junior or senior that is taking uncovered credits could possibly meet or exceed the Hope Scholarship limit by the end of their college career or by the end of their junior career. So that means that a student could possibly graduate without having hope their senior year. Now let's look at line number 189 on page 6 of the bill. And you heard the sponsor talked about the transportation clause or the grant. The only benefit that was eliminated was transportation. I want to say that again. The only benefit that was eliminated was transportation. Transportation is a lifeline, the backbone of this program. You have a child in South Fulton who's a straight A student that's involved in this program, a high school senior. If his parents are working throughout the day hard to make money for that family, that child can't get to Georgia State to take his courses. If you got a child in Brooks County, South Georgia, that needs to get to Valdosta State to take these courses, that child cannot get to Valdosta State because we have no transportation grant. In fiscal year 2017, this General Assembly appropriated $955,000 towards the transportation grant. In fiscal year 2018, it was reduced by $500,000. And what the sponsor just stated to you earlier, the money's completely gone now. What is that sending? What signal is that sending? What is that saying about us? That our most valuable commodity should not be supported? Well, members of the General Assembly, I'm going to talk to you a little bit about selective priorities in spending. This fiscal year, this budget, this supplemental budget that we just passed, we appropriated $1 million of taxpayers' funds towards a consultant for Medicaid waivers to tell us what Democrats have been telling us all along. that Medicaid expansion is the only way, and waivers are not going to move forward. We have also, in this budget for fiscal year 2020, have allocated $150 million of taxpayers' funds for a ballot marking voting machine that's going to be probably obsolete by the presidential election in 2020, and that's going to be subject to possible repeated hacking. I want to say this, and I'm going to end. A wise man once told me, you know a person's heart, but what they do with their time, their talents, and their treasures. Why not treasure our A+, our all-star students by fully funding this program that will help our students continue to achieve? Let's not destroy something that is very successful for our students. And I will yield for any questions at this time, Mr. Speaker.
Did you yield for questions?
Yes.
Chair recognizes Chairman Martin.
Yes.
To your right for a question.
My good friend yield for a question.
Yes, I do.
Isn't it true that I believe what I heard you say is you were for this program, I'm reading on 18 through 21,
yes,
to provide qualified high school students with access to rigorous career and academic courses. Isn't that true?
That's very true.
Isn't it further true that you expressed some concern that somebody could get to college after using up their hours through dual enrollment and all their hope hours and get into their senior year and not have a degree and have to pay for that on? Didn't I hear you express that?
No, what I said is that it's a possibility that Hope Scholarship could reach its limit, and that could be a possibility.
No,
yes,
exactly, and I meant to phrase it that way. I apologize if I did not. So you're concerned they could do it. Isn't it true that under this bill, should it pass, that a high school student would have 30 hours, which is generally construed in semester hours, a full year of college, paid for before any hope hours are accessed? Isn't that true?
I don't think that's necessarily true, Mr. Chairman.
I will respectfully disagree, and when you get out of the well, I would point you to line 25 and 26. It says, covered dual enrollment credit course means up to 30 hours. That's in the bill. So you get that, isn't it true, that you get that paid for while you're in high school before you access any of your hope hours?
Well, what I'm saying is, Mr. Chairman, once that student gets to college, that some of those credit hours for the uncovered dual credit hours will come from the lottery funds, and therefore it will go against their Hope Scholarship limit.
I agree. I agree with that. And isn't it true, we hope those dual enrollment hours, or as the bill says, rigorous career and academic courses that lead them toward a degree. Isn't that true? We hope those dual enrollment hours are doing that.
It is, Mr. Chairman, but I think we're on two different train tracks, because you're talking about hours. I'm also talking about uncovered dual enrollment hours. So if you're talking about credited dual enrollment hours that are credited and covered, yes, you're right. But what if a student wants to take uncovered dual enrollment hours? Then you dip into the lottery fund, and then that will be used against the student on the back end for that Hope Scholarship.
Isn't it true the Hope Scholarship is to help people get a degree?
That is very much true.
Isn't it true it is not there for them to just go take courses? And isn't it further true that 30 hours, 30 semester hours, plus 127 semester hours is 157, is really about 5 years of college? And isn't it true that most people are going to, if they focus on the rigorous career courses that we're talking about, going to be able to get their undergraduate degree, as Hope is meant to pay for, in 157 hours and move on to be job seekers and become part of the Georgia economy? So isn't it true that we have here in this bill the opportunity for our young people to get rigorous courses, move on when ready was what this was originally called, up to 30 hours, and then use their Hope Scholarship to get ahead so that they can get that degree in a short period of time, in a shorter period of time than they could have otherwise, and 157 hours paid for between the state appropriations and lottery funds through Hope is a generous jump start for any student in Georgia to get their degree and become a job seeker. Isn't that true?
No, it's not true at all, Mr. Chairman. And I will tell you the reason why. Because currently the way the system is right now, if you have uncovered dual enrollment hours and dual enrollment hours, those hours won't count towards your Hope Scholarship limit that I've been saying. So I would say in this particular circumstance, we need to take a step back, look at this holistically, look at it from a study committee standpoint, and not just push this bill through today on the vote when we don't have a fiscal note to even know if we're going to save any money to begin with by making these cuts.
Isn't it true? My concern is that we provide our students the opportunity in high school to take these rigorous courses, to move ahead when they're ready, to let them carry that forward with a full complement of 127 Hope hours, 157 hours total, get their degree in perhaps shorter time than they would have without dual enrollment, and become part of the Georgia economy. I thank the gentleman for yielding.
Thank you. Mr. Speaker, at this time I yield the well.
Gentleman has yielded the well. Chair recognizes Representative Stovall to speak to the bill.
Thank you, Mr. Speaker and members. I rise to speak on House Bill 444. A lot of times when we're here voting on legislation, some parts we agree with and other parts we don't. And the part I do not agree with in HB 44, and I think it needs to slow down a little bit, is the effect that it's going to have on those students utilizing the apprenticeship program. That particular program is a unique program across the state where students begin in the 10th grade and they actually will end up earning an industrial maintenance degree. And because there are specifics that has to happen with that particular program as far as the type of number of hours that the children have to earn, there are some cracks in when you talk about the maximum amount of hours that is available in the bill. It does not align with exactly what is needed for those students who are participating in the apprenticeship program. And the apprenticeship program I'm referring to is the one that was started at the Central Education Center in Noonan, Georgia, which I saw firsthand this summer, well, in December, how this program is advantageous for students. And when we look at the bill and it says the purpose is to increase the high school graduation rates, prepare a skilled workforce, and decrease post-secondary students their time to degree completion, it seems that this bill is working against those students. No, there are not a lot of students, but those students have an opportunity, and this particular program has already grown into 2 other areas, one in Spalding and one in Rockdale, and could possibly end up expanding to others. And the unique part about the apprenticeship program is that these particular corporations have invested money in this school. At this particular school in Noonan, on the campus, there is the college, West Georgia Technical College, located on the campus. The high school is located on the campus. And the programs that the corporations paid for, like welding and some of the other programs, that these kids, once they graduate, will have a guaranteed job with these particular companies. Let me give you an example. A 10th grader will start off earning $8 an hour with this program while they're going to high school and technical college and getting hands-on training at that manufacturer's company. When they become 11th graders, their hourly rate moves up to $9. When they're in 12th grade, it moves up to $10. At the end of those 3 years, they can possibly have earned almost $25,000 coming out of school. And once they graduate, they can have an associate's degree. They can also have the industrial maintenance certification that's through the foreign company, like the German company. And they can end up, of course, a high school diploma. And they can now be eligible to earn almost $75,000 as an 18-year-old. So why would we want to put restrictions in the bill that don't allow the restrictions in the bill to make sure that those students are covered so we can expand that particular program? It cuts down on those, and those students who usually participate are those who are looking at, who might potentially end up dropping out of high school. or don't have any further desire to go to a 4-year college, but they're ready to start working. And the impact it has in the community is that these students will not leave school, leave their hometown. They want to stay because the companies are located there. And so if we're able to keep our young people in our communities, making $75,000, how many of you all were making $75,000 as an 18-year-old? Not many. So we don't want to discourage them from participating, and that is the reason I had some hesitation on this bill. Even though the author has agreed to work on it, I said, why not work on it now and make those changes, because we had time to make them even through the committee. Thank you, Mr. Speaker. I yield the well.
Chair recognizes Representative Carter to, you waive? She waives. Chair recognizes Chairman Knight to speak to the bill.
What I've just heard today is probably mixing politics with the future of Georgia's students and their education. I want to tell you that we took this seriously. And from a budget perspective, I drilled everybody, USG, Technical College, and the private college system. And we drilled and we drilled and we drilled. And we wanted to make sure that the dual enrollment program withstood the test of time and actually improved. And that it met its goals. What are its goals? You've heard them here, but some people can't quite get it. What's the intention? The intention is make sure that secondary and post-secondary success rates and degree attainment by students. It's simple. We're giving our kids a head start. Representative Williams talked about why mess with something that's so successful. It is successful, but it's outgrowing and it's out of control. It is out of control. That's the cost that you're seeing rising. All we're trying to do is put simple guardrails up that says, look, it's simple. You got 30 hours plus your hope. Make it count. Put the counselors in so that these kids, contrary to what Representative Bodie says, is not taking uncovered courses. The purpose of this is not only to complete high school, but it is to get you going along your path of higher education. So if you're out there floundering in the wilderness, taking uncovered courses, you're not meeting the goals of dual enrollment. My committee took and again went drilled and drilled and drilled. And we have come up with boundaries. We're leaving this to the educators, to USG, to the technical college system, the private colleges, and the K-12. We're not trying to mess with them. But we're just saying tighten up. That's it. And as far as the two different trains, yeah, we're on two different tracks, and we're going in opposite directions. The very idea that you get up here and you start talking about something else besides education and what is going to make dual enrollment stronger and what is going to sustain it in the future is just simply politics. It has nothing to do with adding value or substance to the conversation of how we make sure that this program is sustainable. Representative Stovall, I appreciate you. Your concern your concern for the apprenticeship program is one that is shared by me. And if you remember, Chairman Lynn Smith has shared that concern. We have taken care of this. That is probably one of the best programs that is out there. And I appreciate you getting up here and talking about the kids and about a valuable part of the dual enrollment program. I sincerely appreciate that. You added value to the conversation. And I will guarantee you that we will protect that. This protects it, and if there's needed changes, we find anything, it will change, because that is something that I would like to see grow and expand. It meets the goals of what we're doing in dual enrollment. Thank you for that. I want to encourage everyone to vote for this bill. This bill helps sustain the dual enrollment program and helps build upon a successful program and makes it even more successful. Mr. Speaker, I yield the will.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. The chair recognizes the chairman of the Education Committee for the chairman's time. Chairman Jaspers.
Thank you, Mr. Speaker. Chairman Knight, thank you for your comments, and I really thank Floor Leader Reeves for his explanation. We have been working on this bill probably since the session started this year, especially in Chairman Knight's committee, which I have a pleasure to serve on. And what this does, the law is bringing it into conformity with what the budget you voted on a few weeks ago does, that we're doing today. Now, many of y'all are suffering from education acronyms. And on our committee, it's a hard thing. And our committee is full of very, very passionate people who really look at education and know and care about the youth of our state and are making sure that we meet the needs of the youth of our state. And that's why I have the fortune to be the chairman of that. You know, this bill does a couple of things that I want to reemphasize. There was an audit done a few years ago that criticized this program for not having a purpose. This bill and this idea hasn't been something we cooked up the last 2 or 3 weeks. It's been studied very carefully. And it really defines it. You can look on line 18 and read it. I'm not going to read it to you. It does 2 other things that I think are critical. You know, the high school counselor is going to be the gate people. They are the gatekeepers to this bill. But we're empowering the colleges and technical schools and other qualified post-secondary providers to get involved. They're not now. You might be surprised to learn that. They are if the kid goes to see them. But this law will require it upon entering the program at 15 hours and at 30 hours. And I like that part very much because it's going to focus the young person on the use of the 30 hours, the lottery funds, and the Hope Grant, even if they need that, and do well with it. It most importantly requires teachers who teach these kids to be employees of the post-secondary institutions. That means that the technical school teacher is responsible for them, and they will be. That's not the case now. And also, SACS accreditation will make sure that rigor is enforced and done, and this on-site overlook. So I can imagine if what you've heard for the last 30, 40 minutes is confusing. So I was a county agent, and I worked with 4-H kids for 30 years. So I draw little maps sometimes for farmers to understand what's going on. So today, when people have been asking me what's going on, I have a little map to show them. And it shows them that we're not harming kids, that we're putting them in the best situation, the best program with the most advantages that's available in the United States. And I'll just kind of go over it real quick, like a 4-H demonstration. If you're in the high school right now, you'll get, if you're a degree or diploma for USG, University System, higher ed, you'll use 30 dual hours. Then you have access to 127. If we're doing it right, you're going to have a year or maybe two going into the USG point. There's nothing wrong with that. At high school, let's say if you want to get a certificate or a technical diploma, okay, that 30 dual hours is there. You got the 127 hours in lottery dollars. If you don't know, that will fulfill any technical certificate. But well, let's say if it didn't. You changed your mind. You did something else. You're out of high school. This preserves the 63 hours that the Hope Grant keeps in there. The same thing for apprenticeships. They mirror what's going on at the technical school. Got the 30 dual hours, the 127 Hope and Lottery. And then if you change your mind, we still preserve the 63 hours. So we've been graciously generous on that. You know, we covered the summer people. We've thought about this. And Floor Leader Reeves is right. This is an ongoing discussion. We find out little things, little wording changes that don't make sense in the bill. You know, we're committed to make this thing right because I've got to tell you, being on education, that's why I love it so much. And the committee that works on this, the committee that works on the higher ed appropriations and lower ed appropriations, K-12, it's all they think about is what's best for children. And Mr. Speaker, I hope everyone can find in their heart to do what's right for the young people in Georgia and vote for this bill, and I yield well.
Gentleman has yielded the well. Previous question has been ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. What purpose does Representative Derek Jackson rise?
Parliamentary
State your inquiry.
Is it not true in 2016, Governor Deal announced for the first time that the Georgia Lottery raised over $1.1 billion for the education and saw record profits of $117 million?
If the gentleman so states, I'm sure he has researched that point. What purpose does Representative Lopez Romero rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, isn't it true that I am on the Education Committee and actually voted for this bill in a good faith effort to continue the dialogue asking for the cost difference or savings that these limitations on the dual enrollment would have, but I did not receive it. And if we have a successful program, then the more intuitive thing will be to actually fund it rather than eliminate or reduce or restrict the students' access to an education to develop a workforce that we need to continue being the #1 state to do business in.
Was there a parliamentary inquiry in there somewhere?
I was asking, sir, if it was not true.
If the lady so states.
Thank you, Mr. Speaker.
All right. Those in favor of the bill are voting aye. Those opposed are voting no. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 444. The ayes are 99, the nays are 72. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 458.
House Bill 458 by Representative Gullett of the 19th to be entitled an Act to amend Chapter 2, Title 25 of the Official Code of Georgia, annotated relating to the regulation of fire and other hazards to persons and property generally, so as to prohibit the use of Class B firefighting foam for testing purposes. This bill has been referred to the Committee on Natural Resources and Environment. That committee recommends that this bill do pass.
Chair recognizes Representative Gullett to present the bill.
Thank you, Mr. Speaker. Members of this body, this is a bill that establishes a statewide uniform requirements that would restrict the use of firefighting foam containing added PFAS substances for training and testing. This still allows for continued sale and use against real-world fires and emergencies today. Just for you guys, it's the legislation. The true meaning of this legislation is it allows firefighters and other first responders to have access to the tools needed for proper training to reduce unnecessary release into the environment, but it ensures the most effective firefighting foams are available to protect life and property. I would appreciate your support for this vote, and for this bill, and Speaker, I yield for questions.
You have a number of questions if you care to yield.
Sure.
Chair recognizes Representative Ridley to your right for a question.
Does the gentleman yield?
Sure.
Can you explain to me what fluorinated organic chemicals are? Is that fluorine?
Say which chemicals? I'm sorry. Is there part
on the description it talks about fluorinated organic chemicals? Is that fluorine?
Well, it's actually PFAS substances. It's called perfluoroalkyl and polyfluoroalkyl substances. So I don't really know that answer completely, but that's the substances that are in there. They're pretty toxic if they build up in your body over time.
Well, do you further
Sure.
yield? So, are you saying that this foam doesn't contain fluorine?
I don't know if it contains fluorine or not. I don't know. It contains these PFAS substances, though. They're chemicals that are
Okay, so
toxic to you.
you couldn't probably tell me what the atomic number of fluorine is, could you then?
I probably could. And you're saying chlorine, am I correct?
Fluorine with an F.
Oh, fluorine. Yeah, I'll find it for you. Give me a second. I'm not even sure if that's an element, but if you know the symbol, I'll give you the number.
Yeah, okay. The atomic number's 9, and the element number's F for
Yeah,
fluorine.
awesome. I see it.
Good
Thank
bill.
you.
Congratulations.
Thank you very much.
Representative, I'm a little concerned when both of your seatmates have questions. I thought you would have taken care of their concerns before you came down here.
Mr. Speaker, I'm concerned as well.
Excuse me?
I'm concerned as well. So.
All right, let's find out what
All
you
right.
should have done. Chair recognizes Representative Moore to your right for a question.
Thank you, Mr. Speaker. Does my respected seatmate yield?
I do.
Isn't it true that I'm a co-sponsor of this bill with you?
You are, and I appreciate your support.
Thank you. Does the gentleman further yield?
I do.
Without looking at your notes, can you spell polyfluoroalkyl?
I probably can't, to be honest with you. I'm not even sure that's the right pronunciation, and I'm not even sure. It very well may be. I may be pronouncing it incorrectly as well, so.
Does the gentleman further yield?
I do.
For the benefit of this chamber, can you explain why these substances are dangerous to the environment?
Sure, yeah. Once they go into once they're used in training purposes, even in emergency situations, they actually leak into the groundwater, and when you drink that groundwater, it builds up into your body, and over time, it's caused a bunch of different ailments and problems with people. As far as they've been found so far, it looks like they've not only is it caused reproductive and developmental problems, liver and kidney issues, especially in laboratory animals that they've tested it on, but ultimately this gets it out of the groundwater for training purposes and testing purposes, and we only use it for emergencies. Thank you very much. Mr. Speaker, I yield the well.
I think you need to go back there and have a scientific discussion with your
No, sir.
seatmates.
I don't
Gentleman
think-
has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 458. The ayes are 170, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 307.
House Bill 307 by Representative Powell, the 32nd, and others to be entitled an act to amend Chapter 10 of Title 15 of the Official Code of Georgia annotated relating to magistrate courts so as to provide for the jurisdiction of such courts. This bill having referred to the Committee on Motor Vehicles, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Alan Powell to present the bill.
Thank you, Mr. Speaker, and ladies and gentlemen of the House. Bring to you today House Bill 307. I want to give you a little bit of background to 307. I've been here 30 years on the Motor Vehicle Committee, and we have put patches and Band-Aids from the head end to the rear end on this issue, and it deals with non-consensual towing. And for those of y'all who don't know what we're talking about, that's towing that's done by the towing companies whenever, for the biggest degree, law enforcement calls them to come get a vehicle. Now, the problem with this bill, and it started before I was ever here, was it started back in the 70s that every time they tried to perfect a method for these towing companies to get rid of these derelicts, for the biggest part, we were hamstringed because the Constitution of Georgia is unique to the point that it says that if you're going to take something, even if it ain't worth nothing, you still got to go through the process. Now, that's the difference between Georgia and all the surrounding states. Most of all the surrounding states have non-judicial foreclosure on these junks. Quite frankly, when they tow these vehicles in, these derelicts, if they were worth anything, the owners would come and get them to start with and figure out how to settle up. But because of that, it's become a public safety issue. Because these junks that you see are these vehicles that are broke down, they're on the sides of the street and the interstate, and they've been in wrecks and all such as that. These towing companies have had to pick them up, and while it might be the problems may be a whole lot more difficult in the metro area than it is in some rest of the state, it's because real estate is of such a high commodity. Now, these towing companies, they're authorized and licensed by the Department of Public Safety to run by their rules and regs. So because of that, they virtually have to pick these vehicles up. Because, you know, a lot of us in the rest of the world, we'd probably say, we ain't going to pick that stuff up if we can't get rid of them. And by the time we fill up our fences and our acreage with it, well, you know, it's just sort of a difficult process. You got 159 magistrates in the state of Georgia. I'm not going to say that all 159 of them operate differently, because they don't, but you do have some that tend to operate a little bit differently. So what this bill 307 is doing is that we're making an attempt to try to put together a process so that these folks that are ordered by law enforcement to pick up vehicles, they have a straight line, understandable process, whether they're down in South Georgia or North Georgia, rural Georgia, or the metro area, so they know what the process is. And that's what this bill does. This creates a situation so that the dealers or the towing operations that have pulled these in, that they have a method of filing and through a legal process of declaring something, if the owners didn't come back of the lien holders, that it can then be declared as abandoned and through the legal process. I can walk with you through it. Probably wouldn't mean a whole lot to many of y'all except maybe the lawyers. But I'll tell you that what we've done is we've done a situation to pacify the magistrate judges. One, and I will tell you that after they have picked it up, they'll notify law enforcement, to NCIC, to see if those vehicles are stolen. Then they've got about 7 days to get the owner of record or the lien holder record from Revenue or Revenue's designee. then they'll send out the first registered certified mail. If it comes back to them and they've been unclaimed, then they have to go the next step. And this pacifies the magistrates that they'll have to post a public publication on that vehicle in 2 of the 3 methods. One would be to hang it in a courthouse on the bulletin board, and then either run it in the general circulation newspaper or the legal organ. Then after 10 more days, then they can file to the magistrate to file a suit for abandonment of that vehicle. At that time, they also then send a copy of that filing to that same owner of record again. If they don't hear from it, then they've got to go through that whole process and run it in the papers for another 2 weeks. This is the process, and that's to be sure that these folks have had due process, they've been notified. Then if not, then the courts can then rule it to be abandoned, to rule that they can then auction off whatever they get for it. If they get more than what their fees for towing and storage and the legal fees are, then that goes to Unclaimed Properties Division, Department of Revenue. Then if the owner of records decides to come forward, they can come forward in up to 6 months and they can claim any overages. If not, the towing operators can do that because they're in sort of a losing proposition. That being said, the general synopsis of this bill, I'll be more than glad to answer any questions. And if not, I sure would appreciate your favorable consideration of House Bill 307. And you will see this back over because this is a continual work in progress with the magistrates.
Do you yield for a question?
Be more than glad to.
Chair recognizes Representative Dukes to your left for a question.
Would the gentleman yield?
Yes, sir.
What is the total duration as far as the time process from when they pick the car up and the actual title ownership changes?
Would you repeat that?
There was a time when the owner or the towing company will be towing the car, and then there is a moment when the title changes. What is the time duration in?
I don't know what there is. I don't think there is a title duration of the title change. It's not a matter of changing the title. If a towing company picks up a vehicle, then they want to, and if they can't reach or get in touch with the owner or the lien holder of record, then they want something to be done, and that's when they have to file. And they file for an abandonment, not for a title, but for an abandonment, because even if it goes through when it goes through that legal process, the judge doesn't issue a title. The judge says it's abandoned, and you can auction that vehicle off, and then whatever it brings, you get your money out, any overages go to revenue. So there's not a new title issued on this.
Okay. Thank you.
Thank you.
You have no further questions.
Thank you, Mr. Speaker, and ladies and gentlemen, I appreciate you will vote for this bill as we thank former Motor Vehicle Chairman Mr. Epps that's sitting over there. He's had to deal with this a year or two.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 307 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 307. The ayes are 167. The nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Please help me welcome back to the House floor a former member of this body, former State Representative Bubber Epps. Clerk will read the caption to House Bill 507.
House Bill 507 by Representative Walensky of the 79th and others to be entitled an act to amend Chapter 5 of Title 48 of the Official Code of Georgia annotated relating to ad valorem taxation of property so as to revise the criteria used by tax assessors to determine the fair market value of real property. This bill has been referred to the Committee on Ways and Means. The committee recommends that this bill do pass by committee substitute.
Representative, I have refused admittance to the well for less than that. Are you in a hurry? Excuse me? Okay. Chair recognizes Representative Walensky to present the bill.
Thank you, Speaker. Members, I present to you House Bill 507. This bill, last year, House Bill 196, what it did is gave the opportunity for landowners of commercial properties to voluntarily submit income and expense information to the tax assessors. It was a good bill and the intent was there and it's still great. What it did though, however, is it used the word utilize, which said that landlords of commercial properties, or excuse me, the tax assessors must utilize the income approach when evaluating properties. And it's been wrongfully interpreted, or the issue with this now is that tax assessors believe that they cannot consider any other approach when evaluating a commercial property. So what I did here is I changed utilize to considered. So now a tax assessor can properly consider multiple ways to evaluate the property. And on top of that, I changed the conjunction to two sentences, so it still allows a landlord property owner of a commercial property to submit to a tax assessor voluntarily, if they choose, the income and expense data that they can also consider. Thank you, Speaker.
You didn't do a very good job of explaining your bill. You have a number of questions.
I yield to questions, Speaker.
I would too when it's the Dean of the House. Chair recognizes Dean Smyrie to your left for a question.
That's Jim Neal.
Yes, I do.
How you feel?
Excited.
How excited are you?
Nervously excited.
Nervous? Okay. Just want to let you know, it took me a long time before I could get my first bill passed. So, how you feel?
Dean, I worked really hard. Thank you.
Well, congratulations.
Thank you.
Let's see. Do you further yield?
Yes, Speaker.
Chair recognizes Representative Kennard to your left for a question.
Does the gentleman yield?
Yes.
Does the gentleman yield to Representative Greg Kennard?
Yes.
Thank you. Is it not true that the official scoreboard is now Republican freshman 11, Democratic freshman 1?
Please don't jinx me.
You yield for one more question.
His bill hasn't passed yet.
I yield.
Isn't it true that I also have a dream of being in the well to pass my bill one day?
If the man says so, I believe it's true.
Do you further yield?
Yes, Speaker.
Chair recognizes Representative Wilson to your right for a question.
Will the gentleman yield?
Yes.
Isn't it true that I have pored over this very much needed but lengthy bill, and to the best of my knowledge, the best I can tell, it changes one word in the code, removes one word in the code, and then removes 8 single quotes? Is that correct?
Yes, words have a lot of power.
Does the gentleman further yield?
Yes.
What do you have against single quotes?
That was a clerical error also in House Bill 196, that it was urgent, it was taken care of very quickly.
Thank you. Congratulations.
I yield the floor, Mr. Speaker, and I ask for favorable consideration of this bill. Thank you.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 507. The ayes are 164, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 83.
Could have been bad. House Bill 83 by Representative Douglas, the 78th, to be entitled an act to amend Part 15 of Article 6, Chapter 2, Title 20. The official code of Georgia annotated relating miscellaneous provisions under the Quality Basic Education Act so as to provide for recess for students in kindergarten grades 1 through 5. This bill having referred to the Committee on Education. That committee recommends that this bill do pass by committee substitute.
Chair recognizes the gentleman from Clayton County and a former Georgia Bulldog, Representative Douglas, to present the bill.
Thank you, Mr. Speaker, to my esteemed alumni of the university. Ladies and gentlemen, I thank you today. You have seen this bill before. It's a pretty straightforward bill, 30 minutes of recess, but I want to give you a little background here of how important it is that we pass this bill. I was in Health and Human Service Committee, and I learned last year that on our health care for the House, or for all people on a state health care plan, 75% are obese. Do y'all hear me today? People, we have a serious problem in our state with obesity. Let me repeat that. 75% of people on our healthcare system are obese. And this is not counting our spouses. Okay? We're in a world of trouble here. And I'm trying to help fix that today. Also, in our state, we only have 2 cold months. Georgia's a pretty hot state. We only have 2 cold months in our whole state, and our kids are at number 8 in obesity in kids. Number 8. Guys, we have to fix this problem. Basically, the bill just says 30 minutes of recess, and it can't be held against the kid for disciplinary problems, and I'll yield for any questions.
Do you yield for questions?
Yes, sir.
Chair recognizes the chairman of the House Ethics Committee, Chairman Nix, to your right for a question.
This gentleman yield?
Yes, sir.
Is it not true that if you have to stay here longer than Representative Smyrie and become the dean of this house, you will eventually get this past both bodies and signed by the governor?
The gentleman knows by what he speaks.
Absolutely.
He didn't take that good care of himself. Do you further yield?
I'll yield for one more, Mr. Speaker.
Chair recognizes Chairman Lynn Smith to your right for a question.
Do you yield right in front of you?
Yes, ma'am.
I just want to commend a true Georgia bulldog who hunkers down and does not give up. Is that not true?
The gentle lady knows by what she speaks. This is the third year for hopefully it's a charm. And I yield the well. Thank you.
It's called finishing the drill.
Thank you, Mr. Speaker. Go Dogs.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 83 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 83. The ayes are 160, the nays are 11. This bill, having received the requisite constitutional majority, is therefore passed. We are going now to the supplemental rules calendar. Clerk will read the caption to House Bill 511.
House Bill 511 by Representative Tanner of the 9th and others to be entitled an act to amend titles 32, 36, 45, 48, and 50 of the official code of Georgia annotated relating to highways, bridges, and ferries, local government, and to repeal and reserve Chapter 32 of Title 50 of the official code of Georgia annotated relating to the Georgia Regional Transportation Authority. This bill having been referred to the Committee on Transportation. That committee recommends that this bill do pass by committee substitute.
Chair recognizes the chair of the House Transportation Committee, Chairman Tanner, to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, I bring before you House Bill 511. I try not to stay in the well too long, but this bill does have some substance, so it does need a little bit of time to go through the merits of the bill. 2 years ago now, the Speaker initiated and we passed legislation creating the House Transit Governance and Funding Commission. I got to thinking about this the other day, but all my Republican members of that commission from this House are either now constitutional officers statewide or they are no longer with us. So Christian Coomer, who is now in the appeals court, Jason Shaw, and Tom Taylor. I also want to thank Calvin Smyrie, the dean, and Mary Margaret Oliver, who also served on that commission, along with all of our non-legislative members for the last 2 years. This commission's done great work. Last year it resulted in House Bill 930, and for the first time we're having a serious conversation about transit, not only in the metro Atlanta area, but all across the state of Georgia. So I know I've had some folks talk about this being all of a sudden legislation, but I can tell you for those of us and those members I just named who have worked on this hours and days for the last 2 years, this has been a great labor for us, and I appreciate the leadership of the House in helping us get to this point. The legislation you have before us, I want to tell you why there's a case for change first. In Georgia, we have transit is managed by 6 state agencies, 27 planning organizations, and over 95 local agencies. The complex structure creates administrative inefficiency and unnecessary red tape. Some parts of Georgia, primarily in rural Georgia, with high poverty rates, do not have access to any type of public transportation, including the Dial-A-Bus program, to help residents access jobs, education, or health care. 36 counties currently lack any public transit system, affecting more than 1 million people in our state. Georgia transit spending lags behind other states. Georgia ranks 37th in the nation and 45th in spending per trip. The American Society of Civil Engineers gave Georgia a D- for transit in its most recent infrastructure report card. The proposed legislation you have before you will eliminate GRETA, or the Georgia Regional Transportation Authority, and replace GRETA with the Georgia Department of Mobility and Innovation, referred to that as G-Mobile as we talk for quick clarification. This organization has a new name, but it will leverage the same offices and the same personnel. So as people tell you that this is increasing bureaucracy, that's just factually not correct. To address the state transit challenges, the bill aims to consolidate, to streamline, and better utilize limited resources by creating G-Mobile. G-Mobile will serve as a lead agency for planning, funding, and policy of mobility and transit consolidation for federal resources into development state policies promoting innovation and mobility across Georgia. It will also streamline the transit services that are currently being provided by the Department of Transportation, the Department of Human Health Services, the Department of Community Health, with an integrated transit link division. This division will plan, fund, and coordinate all transit services outside the metro Atlanta area. I can tell you, as someone who served as a county manager for a number of years, working in local government for 24 years, one of the most difficult things many times was dealing with the bureaucracy in Atlanta. And we had to have inspections from 3 separate state agencies, do 3 separate reports, all for one transit system. There's a better way to move forward. The bill will also, that eliminates GRETA, will also transfer its functions over to the ATL. G-Mobile will be led by a commissioner who is appointed by the governor. The commissioner will oversee the rural transit services, will be the executive director of the ATL, and the executive director of CERTA, again further streamlining the bureaucracy. The Transit Link Division will administer small urban and rural public transit, human service transportation, Medicaid non-emergency transport programs. The division will be advised by an interagency transit coordinating council made up of the commissioner of all the departments that are affected. The legislation also requires that the commissioner promulgate whatever rules are necessary to ensure that all federal dollars are protected. Several other states already have this streamlined process in place and are already doing it under one agency. So again, if you've been told that this is not possible, it's already being done in other states where it's been streamlined under one agency. Opportunity for local and regional input. The bill will also implement a new unified regional operating structure with 9 mobility zones to deliver more consistent level of service across various regions of our state. The operating model enables local participation and leadership while promoting alignment to the overall state plan and policy goal. Each mobility zone will be led by a mobility manager who reports to the commissioner. Each mobility zone includes at least one urban hub city surrounded mostly by rural counties. If you think about the areas that you're from in the state, we have typically cities like Macon, Columbus, Augusta that have urban centers with educational opportunities, healthcare opportunities, jobs, job training, but then around that area is very rural. So we're creating mobile mobility zones around those urban hubs. The mobility zone will have an advisory council who will be made up of local elected officials to give local buy-in that will be appointed by the regional commission chair for that area. You also will notice in the bill that per the Cobb County Commissioner's request, we've extended the opportunity for Cobb County to create a special transit district by 2 years. So that has been extended in the legislation before you. We also have created the opportunity for new state funding. In the legislation, it will allow counties who choose to, and this is already in the law, but in the law today they have to partner with a neighboring county, which is proven to be difficult because most of these larger counties border small communities. But if they want to do a single county transit splosh, they can do that. That has to be approved by the Regional Mobility Advisory Council. Again, that's made up of local elected officials from the area. If the 9 counties that have indicated some desire to do this chose to, that could raise $200 million annually in additional revenue. In addition to this, it would be the intent of this legislation to have sales tax collected on ride shares to go to mobility, to go to this program. I will tell you, there is absolutely no tax increase in this legislation. Originally, we had a 50-cent ride share fee in the legislation. That has been removed, and there is no increase in taxes. There was a fiscal note that showed a deficit because of the change from sales tax to ride share fee, and that has been taken out of this legislation. The bill also includes innovations and programs to incentivize local communities and the private sector to partner to create new mobility solutions. I'm going to tell you about the 3 that we have listed. G-Mobile will manage a 3-year competitive pilot program that will provide corporate tax credits for employer-based transit benefits. After a competitive application process, the Commissioner will select one zone to participate in the pilot. Companies can receive a tax credit if they hire unemployed individuals in their company and provide them with transportation. One of the things we heard as we traveled the state, especially in rural Georgia, is one of the biggest barriers to someone accessing a job was the inability to have good transportation. Another pilot program will provide direct mobility assistance to the unemployed in the very poorest counties in our state. There are 22 counties that fall into the definition that's in the legislation. That is, they have 125% or greater of the state unemployment average, or 75% or below of the average family income. These are extremely poor areas in our state, and those individuals are spread out across 5 of our mobility zones, encompassing 22 counties. Again, this will be a pilot program. The idea is for us to test these ideas to see if they work, and in running the numbers on both of these programs from a business perspective, since there are unemployed people coming onto the payroll, we actually are increasing the revenue coming to the state, not decreasing that. The third pilot program will manage a 3-year program of up to 3 $500,000 grants for a new microtransit service in 3 different ATL districts. This will be technology-enabled on-demand service will be used to improve regional connectivity and access to employment. The program will seek to A, improve connectivity between different regional transit networks, B, expand transit coverage in underserved areas, and C, extend accessibility to employment, education, and training to low-income and unemployed residents in the Atlanta region. Now, the benefits. Building transit programs and funding can allow the state to leverage greater economies of scale for capital cost and purchase of service, freeing scarce resources for transit expansion. Regional planning requirements can incentivize and lead to integration and provide a network and growth of multi-county service delivery strategy. There's ways that we can incentivize a regional approach without requiring that of our local communities. Dedicated funding will ensure that Georgia can invest in transit improvements and innovation to remain economically competitive and better leverage limited federal discretionary funds. By streamlining state administration of transit and improve regional coordination, Georgia can increase government efficiency while expanding service use. Now, that's what the bill does, but I want to tell you one quick story of one of the things that hits home to why this is important. When we were traveling the state, Representative Smyrie, Representative Fowler, and the other representatives in the commission, We heard from a staffing service in Albany that told us a story that they said was repeated over and over in their community. They had a gentleman that needed a job. He was unemployed. He applied through their staffing service. They found him a job. They gave him an appointment to come to their staffing office to fill out, to do the drug screen, etc. He was supposed to be there at 8 o'clock. He failed to show up. They called him again, and he said, I'll be there this afternoon. Then he calls the agency and says, look, your office is 8 miles from my house. The job is 1 mile from my house. He said, I will walk to work, but I cannot find a ride to get to your office to take the drug screen. The staffing office went out and picked him up and brought him to work. He worked and he walks to work every single day and has been since that day. There are people who want to be on our payrolls. There are people who want to be productive members of society, but we have a barrier there, and that barrier is transportation. We've talked a lot about rural Georgia here over the last couple of years. This streamlined process will make it easier to remove those barriers across not only rural Georgia, but also across Atlanta. That's why the Georgia Transit Association, ACCG, and GMA, and the Council on Aging, and many others all endorse this legislation because they understand putting bureaucracy aside, we can solve some serious problems here in Georgia. I want to thank again the Transit and Governance and Funding Commission, the Transportation Committee, and the Speaker and all the leadership in the House that's been involved in getting us to this point. You know, I had a comment from someone who was reviewing the bill in an office. I won't mention which one, but after he finished, he thumped the thing after we were meeting, and he said, you know, this has the potential to be fantastic. And it really does. This has the potential to change people's lives in Georgia. So I encourage you to support House Bill 511. And Mr. Speaker, with that, I'll be glad to answer any questions.
Chair recognizes Chairman England to your right for a question.
Does the gentleman yield?
Yes, sir.
Mr. Chairman, thank you for the work that you and the Transit Council have put into this over the last 2 years. And I know we had a portion of our Rural Development Council about 1.5 years ago where we looked at transit and realized that potentially it was something a little bit bigger than what we had the ability to handle on our own. And we'd asked, Chairman Powell and I had reached out to you and asked you for your council then to look into it. As it related to, and you've mentioned a little bit about it, as it relates to individuals trying to get non-emergency medical transport, get to and from jobs, and the issue where multiple agencies are paying for multiple vans to move people from the same place to the same place at the same time, but because of the way the payment structures are worked out and lack of coordination statewide, it has been a huge issue. And I just want to tell you that I appreciate the work that you've put into this document today, this bill, House Bill 511, and the work that you've done to consolidate all of those issues so that a group of people going from one place to the same place do not have to use 3 or 4 different modes with 3 or 4 different payers to get there. So thank you.
I appreciate that. Thank you, Mr. Chairman. Appreciate the work your council's done.
Chair recognizes Representative Anulowicz to your left for a question.
Does the chairman yield?
Yes, ma'am, I do.
Isn't it true that in many parts of Georgia and even in the metro Atlanta area, we are currently and regrettably underserved by any kind of transit, particularly in rural Georgia?
Yes, ma'am, it is.
Does the chairman further yield?
Yes, ma'am.
And is it not further true that this bill is an important first step in how we address this problem while also encouraging involvement and collaboration with the private sector to help these underserved areas?
Yes, ma'am. The lady knows from which she speaks.
Thank you.
Thank you.
Chair recognizes the Martok Chair, Chairman Silcox, for a question to your right.
Does the gentleman yield?
Yes, ma'am, I do.
I just wanted to thank you, Chairman Tanner, for bringing this bill today because I do think it is a great step toward improving transit service all over our state, and I greatly appreciate your efforts.
Thank you, and thank you for your participation in this, too. Thank you.
Thank you.
Chair recognizes Representative Vance Smith to your right for a question.
Will the gentleman yield?
Yes, sir.
Isn't it true, Mr. Chairman, that
I'm at fault I'm at fault because in years past, in certain positions I've had the opportunity to serve in, we talked a lot about rural transit. We talk a lot about rural Georgia, but I commend you for putting a pen to the paper and actually bringing forth a bill that's caused some discussion, and we know it will continue to be discussion, but I appreciate you doing that. And would you further your?
Yes, sir.
I also appreciate the Rural Council, being from a rural part of Georgia, with a huge hubs or city there too. And I think now's the time that we tag along with ATL, since y'all passed that bill last year, and let's keep this momentum going and serve the people of all of Georgia.
Thank you. As a former commissioner of GDOT and as former chairman of the Transportation in the House, the gentleman knows which he speaks. Mr. Speaker, with that, I know the hour is late, but I ask for favorable consideration of House Bill 511, and I'll yield the well.
Gentleman has yielded the well. Chair recognizes the chair of the House Ways and Means Committee, Chairman Harrell, to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise in support of House Bill 511. We all are familiar with the cliche that the definition of insanity is doing the same thing over and over again and expecting a different result. Chairman Kevin Tanner has been diligent and detailed, and he's provided us an innovative path forward to address transit throughout our state. House Bill 511 is a very bold proposal, and it incentivizes rural transit by placing mobility managers in your communities, developing local projects for local solutions. That's different. This bill has no new taxes of any kind, yet it recognizes the will of this General Assembly to appropriate from growing rideshare revenues funding to implement these rural transit projects. There are 3 incredible pilot programs contained in House Bill 511. One incentivizes by providing transit vouchers for underemployed and low employed, just to answer the very story that Chairman Tanner shared with you, how people can get to work. Another incentivizes a partnership between the public and the private sector to provide on-demand micro-transit systems. We have a pilot program running in my county, in Gwinnett County right now, where you have an app, an on-call, a small 10, 15 passenger bus picks you up and takes you to your destination. You move not in a route where you're forced to get on or off at the same location, but on-call, on-demand micro-transit gets people from their homes or work to the office, to the grocery store, innovative, advanced thinking ideas. And this program also has a pilot program in House Bill 511 to incentivize employers to provide transit incentives for their employees. So I applaud this initiative. We can't continue to do the same things the way we have in the past. This will be local programs for local solutions throughout our state, and I would encourage you to support House Bill 511. Thank you, Mr. Speaker. I yield the well.
Chair recognizes the Dean of the House, Dean Smyrie, to speak to the bill.
Mr. Speaker and ladies and gentlemen of the House, I just wanted to come and say that how strongly I support House Bill 511. Mr. Speaker, if you will recall, when we started talking in 2014 about the transportation bill that we passed, the Transportation Act of 2015, and we talked about additional funding for transportation in our state, then you created the Transit Governance and Funding Committee, and I want to commend Speaker Ralston for doing that and for asking us to serve, because when we met, and I'm just going to give y'all one story. We met in Macon, Georgia, and Brian Anderson, the Columbus Chamber president, was chairman of the subcommittee on workforce development. And Macon was a perfect place to meet because Macon has more cities that are contiguous because it's central Georgia. And we met with all of the community groups, Goodwill, and all of the community-based groups. And from a workforce development, they were telling us how much transit would help people getting to work, people having access to health care. So it's almost a workforce development issue when it comes to transit. So I want to applaud Chairman Tanner and the members of our committee because if you'd have told me 20 years ago that we would be funding transit in this state, and this will be our third time having a transportation bill on this House floor, I just could not have believed it. But the mere fact is that in 2015 we passed the House Bill 170, and then we came back with House Bill 930 last session, which created the ATL. Once we created the ATL, it gave the regional approach to transit in the state of Georgia and allowed those municipalities to collaborate and bring their governments together to make a more viable and a more conducive situation for economic development in this state. I've stated this before, transportation will not guarantee economic development, but I can guarantee you that without transportation, you will not have economic development. Write that down. You will not. So transportation is a key. It's one of our quality of life issues, and this bill replicates ATL. It gives those rural counties and those counties around the state the opportunity to do what we just did in Atlanta and the metro area and allowing them to collaborate and have the same services. And the last point I want to make is that when people say, well, you create another area of government, what this bill does is streamlines government. As I speak, in Georgia right now, transit is all over the radar. It's managed by 6 state agencies, 27 planning organizations, 95 local agencies. Naturally, bringing these agencies together, bringing transit under one roof, to me, is a very, very noble idea. So I'm asking you if you would join with us. To me, this is a major, major piece of legislation. It is a major initiative. Transit is now a major component. When industry come this way, transportation and transit is in the top 5 of the issues that they want to talk about. So to me, I think this is very progressive. This is very forward thinking, very visionary. And I'm asking you if you would please vote yes to House Bill 511, and we appreciate your support. We were able to do it last year for ATL, and MARTA and all of those entities were put in place, and now we're asking you to try to replicate this throughout the state of Georgia so that we can continue to have economic development throughout the state of Georgia. With that, Mr. Speaker, I yield the well.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to withdrawing the committee substitute? The chair hears none. The committee substitute is withdrawn. Is there any objection to adopting the substitute offered by the Committee on Rules? The chair hears none. The Rules Committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 511 will vote aye. Those opposed will vote no, and the clerk will unlock the machine. What purpose does Chairman Pruitt rise?
Parliamentary inquiry,
State your
Mr. Speaker.
inquiry.
Is it not true that in rural Georgia we have a shortage of many things, and one are doctors and dentists? We currently have 17 counties without a dentist in rural Georgia. Transportation is important to children and keeping their health up with both dentists and doctors. Is that not true?
I would agree with the gentleman, and I know that he is very knowledgeable on this issue.
Thank you, Mr. Speaker.
Those in favor of the bill are voting aye. Those opposed are voting no. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 511. The ayes are 159, the nays are 11. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 382.
House Bill 382 by Representative Burns, the 159th to be entitled an Act to amend Chapter 6A, Title 12 of the Official Code of Georgia annotated relating to outdoor stewardship so as to redefine eligible applicants for and recipients of the grants. This bill having been referred to the Committee on Natural Resources and Environment. The committee recommends that this bill do pass by committee substitute.
Chair recognizes the Majority Leader of the House to present the bill.
Thank you, Mr. Speaker. Thank you, members. Mr. Speaker, I'm not quite as excited as Representative Walensky was a while ago, but I'm excited. Members, I bring before you today House Bill 382 because I'm excited about this bill and what it can mean to our state. I'll tell you that. It's a cleanup bill for the Georgia Outdoor Stewardship Act, which, for those of you who were not here last year, this House passed overwhelmingly. House Bill 382 and the Georgia Outdoor Stewardship Act is generational law that dictates a portion of state revenue collected on outdoor recreational equipment to the protection and conservation of our state's natural resources. Now, working in conjunction with the Department of Natural Resources, we have identified some additional language and definitions that will ensure that DNR will be able to properly administer the Outdoor Stewardship Act, which is so very important to keeping this state as beautiful as it is now in the future. In this legislation, we clarify which entities are eligible to apply for grants under the Outdoor Stewardship Act program. These include local governments, state agencies, and non-governmental entities such as environmental nonprofits. In addition, the legislation authorizes DNR to use up to 5% of the funds collected into the Outdoor Stewardship Trust Fund for administrative purposes. However, I will report to you, we have been assured by our partners at DNR that the actual administrative costs will be much lower, and in my conversations with them, I feel very confident of that. But in addition to making to that confidence, this legislation requires that the Department of Natural Resources add an overview of its program administrative expenditures to the annual report that it prepares for the Outdoor Stewardship Act Trust Fund. This will ensure both transparency and accountability in the use of these dollars. Mr. Speaker, that's what this bill is doing for us. This is just a little cleanup to make sure everything is in order so we can move forward on a very important piece of legislation for the future of our state. Mr. Speaker, if there are any questions, I'll be glad to answer them.
You have no questions.
I'll yield the will and ask for your favorable consideration on House Bill 382. Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 382 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 382. The ayes are 169. The nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 392.
House Bill 392 by Representative Wiedauer, the 119th, and others, to be entitled an act to amend Code Section 45-721 of the Official Code of Georgia annotated relating to expense, allowance, and travel cost reimbursement for members of certain boards and commissions. This bill having referred to the Committee on Government Affairs. That committee recommends that this bill do pass.
Chair recognizes Representative Wiedauer to present the bill.
Thank you, Mr. Chairman. Mr. Speaker. I come before you with House Bill 392. It's brought to you by the Georgia Department of Public Safety. What this will allow is for the Board of Public Safety to be able to submit reimbursement for transportation costs to their monthly meeting across the state of Georgia. With this approximate cost of $30,000 per year, that will be assumed into their departmental budget. Learned a valuable lesson the other day. There will not be a fiscal note on this. You will not find it in your notebooks. And no oysters were harmed in the writing of this bill.
Are you yielding for questions?
I yield for questions, sir.
Chair recognizes Chairman Cantrell to your left for a question.
Does the gentleman yield?
I do.
Representative Wiedauer, do you know the record for the shortest bill ever passed in this House?
The shortest bill? I'm unaware, sir.
How long is your bill?
It's pretty short. It is 45 lines.
Am I reading the right bill here? 392? I see 4 words. Isn't it correct your bill is only 4 words?
No, sir.
Line 26?
Yes, sir.
Is that your bill, line 26?
Line 26, yes, there's only 4 words in this. Yes, that is correct. Adding to this bill, yes.
Thank you, sir. Great bill.
Do you further yield?
Sure. One more.
Chair recognizes the Majority Caucus Whip, Representative Kelly, to your right for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
I do.
I was a little distracted there. I wasn't sure if you could answer for me. Was Chairman Cantrell referencing the shortest bill or the shortest member of the House?
I think we'd have to line a few of us up to figure that out. Thank you. I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no. And the clerk will unlock the machine. What purpose does Representative Kelly rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, isn't it true that on Representative Wiedauer's first bill, we were called up with a motion to reconsider, so we didn't clap for him, and he'd like to request that we do that on the second bill?
Show him the love, right?
Yes, sir.
Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 392. The ayes are 160, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 545.
House Bill 545 by Representative McCall, the 33rd, to be entitled an act to amend Code Section 4117 of the Official Code of Georgia annotated relating to treatment of agricultural facilities and operations in forest lands as nuisances. This bill having referred to the Committee on Agriculture and Consumer Affairs. That committee recommends that this bill do pass by committee substitute.
Chair recognizes the chair of the Agriculture and Consumer Affairs Committee, Chairman McCall, to present the bill.
Thank you, Mr. Speaker. Members of the House, I can't, excuse me, I can't think of a bill that has had much more work put into it than this one since the Flint River Drought Protection Act. This bill talks about dealing with farm operations, regulated operations, and legal operations. I've seen some emails that have been sent around to y'all. Amazingly enough, I didn't get one of those, but I looked at them and saw what they said, and what they are saying is basically wrong if you will look at the amendment that was put on your desk about an hour and a half ago. It talks about the distance. We fixed the distance. It talks about international corporations. I believe that if I had made some detrimental comment about a Chinese corporation, I'd be accused of racism. That's what those emails said. It deals with CAFOs, which are combined animal feeding operations, and it takes care of those questions. The bill talks about rendering facilities, and I've had some questions about that. If you look at 41-1-7-3.1, where it talks about the definition of agricultural support facilities, it specifically says that rendering plants are expressly excluded from that definition, which is the definition that we're talking about. We didn't change a lot of definitions in the bill, so we didn't print them. If you'll look at line 56 through 58, that language was written in, and it says the provisions of this subsection shall not apply when a nuisance results from negligent, improper, which I think is a key word, or illegal operations of any such facility or operation, which basically means if they're doing something improper, illegal, or negligent, then they can still be sued as a nuisance. If you have bought any land that is in an agricultural zoned operation, whether you know it or not, in your real estate contract, you signed a piece of paper that said you knew you were moving into an agricultural zone area and that there would be specific noises, smells, odors, dust. It goes into a whole laundry list of things. And if you want to read 44-1-17, that's the language that requires your real estate agent to disclose that to you. The only way we get anything we have, period, is you either grow it or you mine it. Anything we have is the only way you can get it, are those two ways. The growing part in the state of Georgia provides about $75 billion into the economy of Georgia. And in many counties in our state, it's pretty much the total economy of that county. And that's what we're trying to protect, is the economy of Georgia and the economy of many local small counties. You know, several years ago, we went crazy because we had the chance to get the Super Bowl. We took the sales tax off of sporting events tickets so we could get the Super Bowl. Over the last several years, we have been going crazy to get the movie industry in this state, which I think is fine. But I will submit to you that the 10 million Georgians that live in this state do not need the Super Bowl or anybody that plays in it. They do not need the movie industry or anybody that participates in it. But what they need every day, 3 times a day, is somebody to feed them, somebody to clothe them, and somebody to shelter them. And that is provided to you and the rest of the 10 million Georgians in this state by the people who run the operations that we are trying to protect in 545. Mr. Speaker, if there's any questions, I'll try to answer them to the best of my knowledge. Otherwise, I appreciate you voting for the bill. There is an amendment that takes care of a lot of the questions that people have had, that people in the hall have posed. And other than that, Mr. Speaker, if you want to take care of what you eat, wear, and live in, then I'd appreciate you voting for the bill.
You have a couple of questions if you care to yield. Chair recognizes the Chair of the Natural Resources and Environment Committee, Chairman Smith, to your right for a question.
Yes, ma'am.
Gentleman yield.
Yes, ma'am.
Is it not true that I've known you for 23 years as the leader of this Georgia House of Representatives?
I hope you'll still claim that.
Well, checking on your heart, is it not true? It's the most impassioned I've seen you on an issue in a long time. I appreciate the effort y'all put into this, and for heaven's sakes, we still need you. So thank you for your effort on this bill.
Thank you, ma'am.
Chair recognizes Representative LaRicchia to your right for a question.
Does the gentleman yield?
Yes, sir.
Mr. Chairman, is it not true that there are states where people have moved in and then filed lawsuits against landowners for farming operations and about to put them out of business?
Have put them out of business.
Thank you.
Chair recognizes the Majority Leader of the House to your right for a question.
Chairman yield.
Yes, sir.
Mr. Chairman, is it not true that I've been involved with you somewhat on this bill, and there's been much work
Yes, sir.
put in on this bill? Will you further yield?
Yes, sir.
Would you also not agree that as we respect the generations who have lived on the land and lived on the countryside, and you and I are two of them that lived in the country all of our lives.
Yes, sir.
But we want to be respectful and welcoming to those folks who want to enjoy the same lifestyle that we do.
Absolutely, and I don't understand why anybody would not want to enjoy that kind of lifestyle.
And I would agree with you, Mr. Chairman. Would you yield one more
Yes, sir.
question? Don't you believe that this is a fair and considerate policy for the people of Georgia to abide by as they respect our outdoors, our natural resources, and agriculture, the #1 industry in this state, as we go forward in this state?
And it goes hand in hand with any kind of rural development or GOSA or anything else that goes along with it.
Thank you, Mr. Chairman.
Thank you. Mr. Speaker, I'm going to yield well. There's several more bills that's going to take some discussion. Thank you.
Gentleman has yielded the well. Is there, we have one that wanted to speak to the bill. Chair recognizes Representative Dreyer to speak to the bill.
Thank you, Mr. Speaker. I rise in opposition to this bill, but I first want to say that it is not about disrespect to farmers or a lack of appreciation of what farmers do for our state. I've worked very hard on developing community farmers markets in my area and supporting urban agriculture, and actually some of those people are incredible with what they're able to do. My track record is so-so on planting. I'm pretty good with strawberries and blackberries, but not so much with corn, but I'm not going to give up on that. I'm going to keep at it. What I'm more concerned about is, do we have a need, and what are we wiping away with this bill? If you listen very carefully earlier, there was a question about other states have had court cases that have come down that have affected agricultural rights. But that's clearly other states. That hasn't happened in this state. I think there's one out of North Carolina. That is a separate federal circuit than the one that we have. I haven't seen this pending. I think we've got a conservative, well-developed body of law regarding nuisance. It's nuisance law. And the heart of nuisance law is private property rights. Nuisance law is designed to protect private property and the quiet enjoyment of someone's private property. When we're talking about that law, it's OCGA 41-1-1, and it defines a nuisance as something that would, quote, offend an ordinary, reasonable man, end quote. Now, if we're going to find a reasonable man, we probably need to go outside of this building, but we can walk around there and ask a few folks, I mean that tongue in cheek. We find a few folks, enjoying their property means. And I think that means, because there's cases on it, that our property can't be flooded, and it can't be flooded from construction by an upstream property owner. It means that we can enjoy specifically lack of noise. Can't put massive industrial operations nearby that are new and that would drastically affect the quiet enjoyment. And when it comes to private property, I want to read you what the leading Georgia appellate court case says. It says, private property cannot be physically harmed or its value impaired in a negative way, however socially desirable the conduct, without payment being made for harm done. If I'm enjoying my property, and even if it's a good and valid use, but it affects my enjoyment of my private property rights, then there must be some compensation. It's simple rights in contract, rights to enjoy my property, and where someone is infringing on my private property rights and I have lost value as determined by a court of law, then there must be compensation if we get through the court proceeding. There's obviously defenses to nuisance law. It's well established. But you have some classic examples, and that is if someone dams water upstream. We could be talking about just that kind of situation right here, and that either takes away water from my property or it results in flooding or massive pollution on the water on my land. I'm not talking about just a little bit of this chemical or a little bit of that chemical that I heard earlier and I can't pronounce. I'm talking something that affects my ability to use my land because of the pollution. So going through a court proceeding on this, if I claim that I have had my private property rights violated, I've got the burden of proof. I've got to show that I had a use and enjoyment of that property. It's my right, and I got to prove that an ordinary, reasonable person would be offended by what's taking place on my land, and then I got to prove that someone else caused it, and I got to show that with certainty. Got to show that to the satisfaction of the judge, and then I got to show that to the satisfaction of a jury, and then I got to prove the level of my damages. I've got to show that it has severely impaired my property before there would be any kind of substantial payment. Let's talk about what this bill does. This bill changes the statute of limitations. So my rights to bring a claim, how much time I have. Currently, under Georgia law, it is a 4-year statute of limitations to bring a nuisance claim. This changes that to 1 year, okay? 1 year. I will, as an aside, say that I've read the amendments very carefully. I appreciate what the authors have done. They have certainly made it vastly better than it was. Previously, this said if you're over a half a mile and 1 step away, you're not going to be able to bring a nuisance claim. But what it still does is it says 1 year from the date of the nuisance, you cannot bring a claim a day past that. When you're talking about, I think the underlying current is here, if people are moving in to an area where there is agricultural interest, we obviously don't want to stop those, but that is regarding a change in conditions and the surrounding use of the land. Change in conditions is a term of art. That's what's important. That's what that North Carolina case addressed. Now, this bill does not go at change of conditions. It limits the statute of limitation to 1 year. And there's something in the amendment which is good meaning, but I think it creates a problem. It says if there is a new use, a change in zoning law, a change, not zoning, but a special use for this that's been passed through zoning, and someone is entitled to it drastically expand. So if someone is going for a factory pig farm and they get a permit for that, you have 1 year from that change to bring your nuisance claim. Now, none of us want that brand new, massive facility that triples, quadruples or more the number of pigs that are being raised within a mile of our house, okay? But guess what happens? If you get this zoning exemption and this person is allowed to put a massive new pig farm just down the street from you, you have a year to bring your case. But under the wording of this amendment, they can wait a year to begin construction. And you have no rights under this bill to bring a nuisance claim because the 1-year statute of limitation has already expired. That's very important. There's a loophole. If someone massively expands an agricultural purpose, such as raising pigs on a factory farm basis, and they get their special permit to expand and they wait 1 year and 1 day to start constructing that facility, we are taking away your rights, your private property rights to bring a claim. So I would love to support farmers. I would love to be able to grow corn a little bit better, but this is doing away with the massive body of law to protect people under nuisance, and it's infringing on private property rights. Mr. Speaker, I can take questions.
Chair recognizes Chairman McCall to your right for a question.
Gentleman yield.
Yes, Chair.
Is it not true that I appreciate your opinions and you and I disagree on the 1-year deal? I think if you are changing from, say, a 100-head mama cow operation to a 5,000-head feedlot operation, that runs you into being a CAFO. And the amendment says that you have to get a permit from the state. And I think the 1-year time clock starts when the operation commences, not when you file for a permit. That's what the common knowledge is. It doesn't say that specifically in that amendment.
I certainly do respect your opinion as well, Mr. Chairman. First, though, we do agree that there is a 1-year new statute of limitations, and I see exactly what you said on lines 6 and 7 of the amendment. But it says anything that the operation that requires permitting or approval shall constitute a newly established date of operation. And if I wasn't clear, I should have been. What I think you can do is you can get that special permitting, you can do something small with that special permitting, and you can wait a year and a day to massively expand that operation at that point.
For the year?
Yes, sir.
But is it not true anytime you make a major expansion into anything, from drilling a hole for an irrigation pump to a major expansion and a livestock operation, you still have to go back and get a permit from EPD?
Mr. Chair, I could be wrong on this, but what I'm concerned about is you get the permit for the massive expansion, you only go 1 inch of the 100 yards, so there's really no downstream nuisance, and then you wait a year and a day to fully use the permit that you earlier received.
Will you further yield for one more and I'll leave you alone?
No, yes, sir.
One example you gave was damming up a creek and stopping the downstream neighbor from using the water.
Yes, sir.
And you probably don't know, but is it not true that Chair Lady Smith and myself have done more water legislation over the past 20 years than anybody in here has ever dealt with? And we are under Eastern water law, which is regulated riparian rights, and that is already in law that you cannot do that.
Chairman McCall, I think you are probably right about that, but maybe I went a little too far with that. But what I will say is the nuisance law that I looked at does involve changing banks to creeks so that there is downstream pollution. And I'm not talking about a little pollution. I'm talking about massive mud runoff. So those are the situations that I usually see done in nuisance law type cases.
And I appreciate your discussion. Thank you.
Thank you, Mr. Chair.
Do you further yield?
I do, Mr. Speaker.
Chair recognizes Representative Walensky to your right for a question.
Thank you, Speaker. Do you yield?
Yes, I do.
In terms of nuisances in Georgia, I think regarding this, you missed a very important one. Here in Georgia, we have a nuisance for noxious smells. That's unpleasant smells. How do you think that nuisance claim would interact with this statute?
Well, I think that would be incredibly important, and the representative asking the question may have more familiarity with that. I would imagine that it takes some pretty incredible impact to constitute something that would interfere with a reasonable person's enjoyment of their land.
Thank you.
Thank you.
You further yield?
I do, Mr. Speaker.
Chair recognizes Representative Cannon to your left for a question.
Thank you, Mr. Speaker. Do you yield?
I do.
Okay, so to the chair's point, I want to talk about water here because most folks don't know, but I grew up in Albany, Georgia, and I experienced floodings and droughts, and so water is super important to me. So to that point, the Georgia Water Coalition has been something that I've been watching for years. I mean, they've had publications biennially, 2002, 4, 6, 8, 10, 13, 15, 17, 19. We're here. I'm so excited if y'all haven't got your copies. And so the point is there's a bunch of different organizations that are within that coalition that help to talk about how water rights and water is affected, you know, across the state. And so, like I said, the Albany, Georgia Audubon Society and the Atlanta Audubon Society and the Atlanta Water Gardens, the Coyote Project, the Whitewater Club, there's Georgia Wand. I mean, there's a lot of different organizations that have been reaching out about how this affects water. And so I'm trying to understand, how does this issue affect water? The chair started talking about a little bit. You started talking about streams and creeks, and help me get that.
Yes, Representative Cannon, and I'm a paddler, and I've been all over Georgia paddling, but the classic example is you're enjoying your property somewhere upstream, someone comes and does a neighborhood development, they don't comply with code, and they don't put up the barriers to stop the silt from running in, so all of a sudden you get a massive infusion of silt on your property that runs downstream on a river or creek.
Okay, and then do you further yield?
I do.
Okay, so there's this term that folks are talking about called environmental justice. How does this affect what people are calling and saying environmental justice?
Representative Cannon, this would limit people's ability to use established law through the court systems to protect their rights from the infringement on their private property.
Okay.
So it would remove opportunities for justice.
Okay, and then one more, if you yield.
Yes.
So how does this affect folks who are low income when they're going through these court cases? What kind of impact will it have on communities of color?
I'll tell you my biggest concern is if someone is savvy, if someone who does something that would constitute a nuisance under current law and they know it, and they find someone that's being impacted, if they can just tell them, hey, we're going to fix it, give us a little more time, don't worry, I got this, come sit down with us, give us this amount of time, give us this many months, and someone is allowed to, someone who's unsophisticated, someone who doesn't have experience with the law or contracts or the statute of limitations, they could completely lose their right under a 1-year statute of limitations. Thank you. Okay. I yield the well. Thank you, Mr. Speaker.
Gentleman has yielded the well. There is an amendment. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. There is an amendment on your desk. It is AM 450024ER. Clerk will read the amendment.
Amendment offered by McCall, the 33rd, Fleming of the 121st, offers the following amendment. HB 545 LC 44 1190S by replacing 1/2 mile with 5 miles on line 54. By replacing line 68 with the following. Facility of a previously established date of operation. provided that any subsequent addition or expansion, change in ownership, size, or type of operation of a facility or operation named in subsection C of this section, code section, that requires permitting or approval by a state agency or authorization by a local zoning board shall constitute a newly established date of operation. This amendment is printed and on your desks.
Is there any objection to adopting the amendment? Any objection to the adoption of the amendment? The chair hears none, and the amendment is adopted. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 545 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 545. The ayes are 107, the nays are 58. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 516.
House Bill 516 by Representative Smith of the 133rd to be entitled Act to amend Chapter 15 and Title 43, the official code of Georgia annotated relating to professional engineers and land surveyors so as to provide for the professional structural engineer. This bill having referred to the Committee on Regulated Industries. That committee recommends that this bill do pass.
Chair recognizes Representative Vance Smith to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, House Bill 516 will add the term structural engineer to the list, along with professional engineer and land surveyors, as a designation in the state of Georgia on the license. Clients come and look for structural engineers to bid on projects, and that designation is very, very important. 24 other states have it, and we need to have it in Georgia, having structural engineers listed on the license. So I would appreciate your favorable consideration, and if there are no questions, Mr. Speaker, I'll yield the will.
You have no questions? Gentleman has yielded the will. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 516 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 516. The ayes are 164, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 247.
House Bill 247 by Representative Silcox of the 52nd and others to be entitled an act to amend Chapter 5 of Title 16 of the Official Code of Georgia annotated relating to crimes against the person so as to repeal an enhanced penalty relating to battery against a person 65 years of age or older. This bill having been referred to the Committee on Judiciary. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Silcox to present the bill.
Thank you, Mr. Speaker. I bring to you this evening House Bill 247 from the Prosecuting Attorney's Council and the Elder Abuse Council. This bill does three things. Number one, it removes the language in lines 16 through 19 since this crime against the elderly was made a felony under a bill we passed in the 2018 session. On the second page, lines 41 through 43, it specifically expands the definition of exploit to include the taking of an elderly person's resources due to mental or physical incapacity of that elderly person. And finally, it allows the Department of Community Health to contract with local law enforcement to instigate potential elder abuse or exploitation in unlicensed personal care homes. If there are no questions, Mr. Speaker, I will yield the well.
You have no questions.
Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 247. The ayes are 170, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 282.
House Bill 282 by Representative Holcomb of the 81st to be entitled an act to amend Article 4, Chapter 5 of Title 17, the official code of Georgia annotated relating to the investigation of sexual assault so as to increase the amount of time that law enforcement agencies are required to preserve certain evidence of sexual assault. This bill having referred to the Committee on Judiciary, Non-Civil. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Holcomb to present the bill.
Thank you, Mr. Speaker. 20 years ago, I was a young prosecutor, and one of the first cases that I handled was a young lady who had been sexually assaulted. And I was able to get a guilty plea by the defendant, but we had to go through a sentencing hearing. And when we went through the sentencing hearing, the judge gave an incredibly light sentence. She had to testify, and she came up to me afterwards and she said that she felt like she had been victimized again. And I share that with you because I've worked on these issues for some time, and I want you to know why. I felt like I failed her back then, and it still pushes me today, 20 years later. Another case that I handled was a very brutal rape case, and the victim, after it happened, considered suicide. And with the love and support of family, I was able to get through it. But the family told me how different the survivor was before the crime and then after the crime. These crimes change and damage lives to a degree that is really incredible. So a few years ago, as many of you know and many of you helped with,
this House passed legislation to address the backlog of untested sexual assault kits. Through that legislation, more than 3,000 kits have been tested, and we have identified serial rapists, and we have had hits through the DNA database to hundreds of cases. I very much appreciate the bipartisan work that has gone into this, and I've always been very appreciative of you, Mr. Speaker, for your leadership on this issue. And so what are we doing today? What we are doing today with House Bill 282 is to continue this work. On our laws right now is we have a time period where we only preserve the evidence for 10 years. We've done a lot of research on DNA evidence and best practices for holding. And so what we're going to do today is we are going to update the code to remove this 10-year period, and there is a different code section that will then apply. And that other code section is 17-5-56, and it will require the state to hold on to the evidence for the period of time that the crime remains unsolved or until the sentence is completed, whichever is later. And why is that important? It's important because now that we've done all this testing, it may take time, it may take even decades for us to get a match to the DNA to the person who did it. And in fact, 2 days after I filed this bill, evidence from the DNA testing that we've done by addressing the backlog linked a suspect to a rape that occurred in Cobb County at gunpoint in 1994. So if we had followed our law and discarded that evidence after 10 years, we wouldn't be able to then prosecute and bring justice for that survivor. So before I close, I want to just share with you that over the last few years, I've had so many conversations with victims of sexual violence, and they've left me both heartbroken, truly, and inspired by their strength, and inspired so that I use my voice to try to help them and create better policies for the survivors. And so I hope that you will join me in voting yes on House Bill 282. I'd be happy to answer any questions.
You have a couple of questions if you care to yield.
I will, Mr. Speaker.
Chair recognizes Chairman Stevens to your left for a question.
Does the gentleman yield?
Yes, sir.
Is it not true that your bill will not only help convict folks, but it'll help exonerate those that have been convicted?
Yes, sir. Thank you for saying that. And it's supported by both law enforcement and defense attorneys.
Do you further yield?
Yes, sir.
Chair recognizes Representative Cannon to your left for a question.
Thank you, Mr. Speaker. Do you yield?
Yes.
Thank you for your hard work on this. Is it not true that in 50 years, that'll be 2069, and in 50 years, there might be some people who are still around, but there might not be some others who are still around?
We're actually making it even stronger by we're changing it from the 50 years to the time period that the crime remains unsolved. We're actually extending it even more with the amendment that should have been put on your desk.
Thank you.
You're welcome.
No further questions.
Thank you, Mr. Speaker.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to withdrawing the committee substitute? The chair hears none. The committee substitute is withdrawn. Is there any objection to adopting the substitute offered by the Committee on Rules? The chair hears none. The Rules Committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 282 will vote aye. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 282. The ayes are 173, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair wants to recognize on the floor of the House a former member of this body, former State Representative Keisha Waits. Clerk will read the caption to House Bill 381.
House Bill 381 by Representative Abstration of the 104th and others, to be entitled an act to amend Code Section 19615 relating to child support guidelines for determining amount of award, continuation of duty of support, and duration of support. This bill having been referred to the Committee on Judiciary, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Abstration to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, House Bill 381 is the annual Child Support Commission update. Representative Barr serves on the Child Support Commission and brought this legislation to me. This matter has been vetted in judiciary and would ask for your favorable consideration of the update. Mr. Speaker, I'll be happy to stand for any questions.
No questions.
I'll yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 381. The ayes are 162, the nays are 6. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 405.
House Bill 405 by Representative Knight of the 130th to be entitled an act to amend Part 1 of Article 2 of Chapter 5, Title 48 of the Fiscal Code of Georgia annotated relating to property tax exemptions so as to modify provisions related to the Level 1 Freeport exemption. This bill having referred to the Committee on Ways and Means, the committee recommends that this bill do pass.
Chair recognizes Chairman Knight to present the bill.
Thank you, Mr. Speaker. This will be the second bill before you today where we seek to clarify the code in regards to the tax assessment process. Representative Walensky had the first one. Seems we're always coming back to make sure clarification. Maybe one day the tax assessment process will be uniform and everything will be interpreted in the same way. This is a bill that seeks to make two clarifications to the Freeport exemption perspective. One is it adds the definition of affiliate from affiliate company in, and it also makes sure that remanufacturers already in there includes repairs only on the modification of a manufacturer's own product. And again, this exemption only applies where in the counties where the citizens have already authorized a Freeport exemption. Mr. Speaker, I encourage members to vote for this. This is good for our Georgia manufacturers and is helping keep Georgia a great place to be. With that, I'll take any questions if there are any. If not, I yield the well.
You have no questions. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 405, the ayes are 166, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 490.
House Bill 490 by Representative Ridley of the 6th and others to be entitled an act to amend Part 12 of Article 1 of Chapter 1 of Title 7 of the Official Code of Georgia annotated relating to deposits of deceased depositors, so as to make changes relating to the payment of large deposits of the deceased intestate depositors and the deposit of sums held. This bill having been referred to the Committee on Banks and Banking. That committee recommends that this bill do pass.
Chair recognizes Representative Ridley to present the bill.
Thank you, Mr. Speaker. I bring to you House Bill 490, and what this bill is, it's already a current law. If somebody passes away and they have no family, and we go through all the steps and don't have a will, then in current law right now, that there's an affidavit that you can fill out and take to their bank, and the funeral home or any last-minute medical expenses can be paid out of that account. So what we've had to do, the affidavit has not been updated since like the 1980s. So we've updated that. Currently, you have to wait 90 days. We changed that to 45 days, and currently now in law it's $10,000 maximum amount. We've moved that to $15,000 maximum amount. This has got the support of the Community Bankers Association, Georgia Bankers Association, and most importantly, the chairman of the Funeral Home Caucus, Ms. Patty Bentley. And that ought to do it all right there. But that's the bill, and Mr. Speaker, I'll yield for any questions.
Chair recognizes Representative Erica Thomas to your left for a question.
Does the gentleman yield?
Do I have to?
You do.
Okay, yes, ma'am, I yield.
So on behalf of Representative Patty Bentley, who's not here today, but she is on the phone with me right now, and she just wanted to make sure, is this going to be helping the funeral homes or hurting the funeral homes?
This will absolutely help the funeral homes.
Does the gentleman further yield?
I'll further yield. Go ahead.
Excuse me? Okay, she said this is going to be helping. All right, she said thank you. It's good to go.
Chair recognizes Representative Rick Williams to your left for a question.
Does the gentleman yield?
Yes, sir.
Is it not true that you have experience working in the funeral homes and you're an honorary member of the Funeral Caucus?
I'm a member of a lot of caucuses, the Bald Caucus, Funeral Home Caucus, Caucus of One some days. Yes, sir, I am.
We appreciate your hard work on this bill, and I know that will be a comfort and a help to a lot of families, keeping them from having to go through a probate court, setting up a administration of an estate, and this will help a lot of families avoid that also. Thank you for your work on this bill.
Yes, sir, thank you. Mr. Speaker, I'll yield the well.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. What purpose does Representative Williams rise?
Thank you, Mr. Chairman. To invoke Rule 133 on this
Gentleman
issue.
has that right, and the journal will so reflect. Members in favor of the bill are voting aye. Those opposed are voting no. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 490. The ayes are 165. The nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 424.
House Bill 424 by Representative Silcox, the 52nd, to be entitled an act to amend Code Section 1615.3 of the Official Code of Georgia annotated relating the definitions regarding street gang terrorism and prevention so as to include certain sex crimes into the definition of criminal gang activity. This bill had been referred to the Committee on Judiciary, Non-Civil. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Silcox to present the bill.
Thank you, Mr. Speaker. I rise this evening to bring to you House Bill 424. House Bill 424 is a companion bill to Chairman Efstration's sex trafficking bill 234. It does 3 things. Section 1 of the bill adds the offenses of trafficking persons for sexual servitude, keeping in place of prostitution, pimping, and pandering to the definition of potential criminal gang activities. Section 2 of the bill adds trafficking persons for sexual servitude, keeping a place of prostitution, pimping, and pandering also to a list of the offenses where a complainant's past sexual behavior may be admissible into evidence, and thus the rape shield can be pierced by the prosecutor if the procedure prescribed for the prosecution is followed and certain evidence is presented. The third section of the bill clarifies the child hearsay exception so that child hearsay can be admitted at the time of the trial and not at the time of the offense. If there are no questions, Mr. Speaker, I'll yield the well.
You have a couple of questions if you care to yield.
I'd be glad to.
Chair recognizes Representative Walensky to your right for a question.
Thank you, Speaker. Does the chairman yield?
I do.
On line 120, evidence of specific incidents of a victim's or complaining witness's sexual behavior could have reasonably believed. Can you explain me what's going on there, just so I can understand?
I can't hear you. I'm sorry.
Sorry, the microphone. Line 120 through 123. Can you explain to me what's going on there? Is it